Okay. Good morning, everybody. How are you this not so warm morning? Excellent. So, first and foremost, apologies for the slightly delayed start. I know a few of you were here quite early, so apologies, but I think now we have a quorum to start, so we can get on with the business of the day. So I'd like to welcome you all to the second annual ICC Kenya International Conference on Arbitration and ADR, and it is such a pleasure having you. First things first, I would like to recognize and appreciate a few people because first person I'm going to recognize, if it wasn't for him, this wouldn't be happening. I would like to recognize and appreciate Mr. Patrick Obath, the chairperson of the ICC Kenya. Thank you very much. Second, I would like to recognize and appreciate Diamana Diawara, who is the Director for Arbitration and ADR for Africa at the International Chamber of Commerce. Thank you and welcome to Nairobi. I'd like to also recognize Pascalina Kagunda, who was around a few moments ago, who is the Secretary General of the ICC Kenya, Mr. Alim Visram, who is the Chairperson of the ICC Kenya Commission on ADR and Arbitration. In the room with us, we also have Professor Gidon Wigai, Senior Counsel. Congratulations and welcome. Mr. Kamau Karori, Senior Counsel as well. Watching us, I think joining us on live stream, we have Dr. Willie Mutubwa, who is the Chairperson of the Chartered Institute of Arbitrators, Kenya branch. And we also have Njeri Karaoke, who is our representative or sits as the ICC Court of Arbitration in Paris, representing Kenya. Njeri. And we also have Honorable Retired Justice, Lady Justice Mary Yangawa in the room. So welcome. Okay. So to begin, I think we take care of a few housekeeping rules, I think. First and foremost, we do have people joining us on live stream, and there will be some of our panelists who will be joining us virtually. So we will make provisions for them and make sure that they're well accommodated. I would also like to let you know that you can tweet ICC Kenya, you can hashtag ICC Kenya. If you're going to be tweeting and on social media, Facebook, LinkedIn, posting about the event, please feel free to do so. Tag ICC Kenya while you do, and we will see that we can get quite a large reach and promote this conference. We're trying to get as many people interested in ADR as possible. So feel free to spread the word and to essentially be our ambassadors. Okay, I'm going to skip a few things that we're supposed to do due to time constraints. So I think what I'll do is I will quickly introduce our first moderator for the first panel. Okay, so our first panel is going to be moderated by Mr. Alim Visram, who is, like I said, the chairman of the ICC Commission for Arbitration and ADR. He's also a founder and principal lawyer at Visram & Co. Advocates, which is a Kenyan-based law firm, and he's also an adjunct lecturer at Strathmore University School of Law, where he teaches international commercial arbitration. He also tutors for the Chartered Institute of Arbitrators, Kenya branch, and is a member of the Journal Editorial Board at the NCIA, which is the Nairobi Center for International Arbitration. So we would like to then take this opportunity to welcome Mr. Alim, and we can't wait to hear what your panel has to tell us.
Thank you very much, Shiko. I'd like to start off first by making a few welcome remarks before we proceed with the panel. I'd like to start off by saying, distinguished guests, senior counsels, our partners, our generous sponsors, fellow practitioners of ADR, ladies and gentlemen, good morning and welcome. As Shiko said, my name is Alim Visram, and I am the present chair of the ICC Kenya Arbitration Commission, and it is my privilege and great pleasure on behalf of the Commission to welcome you all here today. We are delighted to have you participate and share in this special occasion, our second annual International Arbitration Conference. Thank you all for coming. That many of you have made the time and even willingly traveled long distances to be here today serves as a reminder to us all of just how important our work is. As a brief background, the ICC Kenya Commission on Arbitration and ADR was established last year in November 2021, immediately after our first conference, which was held in September 2021 and was organized by us as a steering committee. Since then, as we embark on our second annual conference, we have officially obtained the status of a national commission and now have representation at the global level in the ICC. For those of you who do not know, our role as a commission, broadly speaking, is to firstly build capacity of Kenyan practitioners specializing in dispute resolution. Our second mandate, broadly speaking, is to engage with a range of stakeholders across Kenya and the continent to identify how the ICC can expand its services to meet the needs of businesses. In addition to that, we have a role of highlighting the benefits of dispute resolution via events in Kenya with the aim of promoting the ICC's reputation as an institution of excellence in service and delivery. And finally, we have a role in building membership of the institution to create links among arbitrators, counsel, and users to enable ICC dispute resolution to respond to the needs of private entities. In this regard, I'm proud to say that since our inception, a little less than a year ago, we have made great strides towards the continuous realization of these goals. I'd like to share briefly a few of our accomplishments. And as I do so, I'd say from the outset that our accomplishments are the fruits of many hours of selfless and devotion by our members, our secretariat, and our subcommittees, all of whom are here today and all of whom I have the privilege of serving with. Some of the achievements I'd like to highlight are, firstly, we have formed new partnerships with reputable arbitral institutions, namely with the Nairobi Center for International Arbitration, and we have partnered with the Chartered Institute of Arbitrators Kenya. Second, we have introduced training programs. Some of the examples are the Arbitral Secretaries Training, which we held in September last year, the arbitral process in an ICC arbitration in partnership with CIARB, which was held in July earlier this year, and the arbitral process and active case management, which was held here yesterday as part of our conference at Movenpick. We have also begun a series of webinars as an avenue to educate, train, and inform our members, the private sector, and stakeholders at large what arbitration and ADR is. Examples of our webinars include a webinar on the resolution of commercial disputes through ADR mechanisms, which was held in June earlier this year in partnership with both the NCIA and KEPSA. We also had a webinar on the enforcement of arbitral awards, which was held in June earlier this year. Further to that, we have expanded our Arbitration Commission. As the work of our commission has grown, we have actually grown the commission's resources as well. And this year, we added 4 new members to our commission, creating a team of 7 members. Those 4 new members were all women, and we hope that this also reflects our commitment to gender diversity. We have also established new subcommittees, such as the subcommittee that helped to prepare today's event. And these subcommittees will be expanded over time as we allow for greater participation and inclusivity in our decision-making processes. Finally, we have expanded our membership. And as a result of our hard work, dedication, and with the efforts of our partners, the ICC Kenya has grown its membership by 65% this year. It is our hope that by the end of 2022, we will have grown by 100%. Finally, and last but not least, we have deepened our relations with the ICC globally, especially the Office of the Director of Arbitration and ADR in Africa. To that end, I would like to acknowledge Diamana Diawara, who has been a tremendous support to us and is here with us today. I would also like to introduce you to our ICC Kenya Arbitration Commission team. Some of them may not be here right now, but those who are, if you would kindly stand as I call out your name, it would be of benefit for the others. Our commission members include Nikhil Desai, who is the Deputy Director, Mr. Gordon Ogola, who I know is here as well, Ms. Mercy Okiru, Kenneth Miriti, Wanjiku Karanja, who is our MC as well, and we have Noreen Kinunduhu, and we have an ex officio member who is Tabitha Raore, who actually heads the ICC YAF. Tabitha, thank you for being with us as well. We also have an arbitration subcommittee team who I hope are present. I see Catherine Molden here with us. We have Michelle Jaguna as well. And we have Gordon Odwar, who I hope is here with us as well. Finally, last but not least, the most important people in the ICC team, our secretariat, Lloyd Mwaniki. Lloyd has been instrumental in putting everything together. Ms. Cheyenne Richu, who's in the back over there, and Mary Obara, who many of you will have received countless emails from, if not harassing telephone calls as well. I hope that you will all have the opportunity to meet with our members in our team, and that we will all get to know each other better over the course of this conference, and hopefully later on in the evening, for those of you who are still around, perhaps for a cocktail. As we begin our second annual conference, the theme of our discussion today is emerging trends in arbitration and ADR across Africa. Our theme is inspired by several events that have taken place in Kenya and across the continent, including firstly, the growth and expansion of arbitral institutions across Africa. Secondly, a surge in international trade and investment in the region, including investment in infrastructure projects in Kenya and across the continent. And third, the opening up of new markets with the African Continental Free Trade Agreement and related cross-border disputes ensuing. These and other events mark significant changes in leading to an increased uptake and preference for arbitration as the preferred method of dispute resolution. To that end, we are honored to have here today with us esteemed panelists, specialists, and leaders, many of whom have been professionally involved in such disputes and who have generously offered to share their unique experiences and their perspectives with us today. Prepare to be excited, challenged, and inspired. Finally, as I conclude my welcome remarks, I would also like to thank our sponsors, without whose generosity today's event would not be possible, or if so, perhaps at a much less attractive venue. I'd like to thank and recognize in particular KEPSA, Mohammed Wigai and Company Advocates, IKM DLA Piper, J. Miles and Company, the Chartered Institute of Arbitrators Kenya and YMG, the Arbitral Women, NCIA, and TDMI, as well as our in-kind sponsors, which include Nestle, Beverage 360, and Fresh and Direct. To all of you, we are grateful. Before I hand back over to our Master of Ceremonies, I want to say once again, on behalf of the Commission, how wonderful it is to see so many of you here today with us. Thank you, and karibu sana. So, I will actually call and introduce our next speaker, Mr. Patrick Obath, the chairman of ICC Kenya. Patrick, welcome.
Thank you very much. I hope you can hear me despite the fact that my speaker is down, the microphone is down. The Director for Arbitration and ADR for Africa at the International Chamber of Commerce, Yamana Jayawara, good friend. Welcome to Kenya, and thank you very much. And all protocols having been observed earlier on by the MC. I'd like to thank each of you for making it here today. It's very gratifying for me and the team at the ICC Kenya that the ADR Commission that was formed by a group of die-hard arbitrators and lawyers a few years ago is now actually up and running and really leaping into greater heights. And really grateful that you've been able to organize this second conference, as well as the workshops that I had yesterday. From what I've heard, they were very, very well received by the people who took part in those workshops. Just to give a bit of a history for those who don't know, the ICC Kenya has been sort of working to establish itself, and as usual, we met challenges that you normally don't really expect, except for some places in Africa. When we were formed, the first thing we discovered that somebody had registered our name. So we had to find a way of getting our name back as ICC Kenya. I think this was during the ICC conference, the International Criminal Court issues that happened at that time. They probably thought that the International Criminal Court was going to open an office in Nairobi. So somebody registered that name. But we were able to get it back, but it took 3 years. And then after that, I think we then started work as the ICC. And the ICC Kenya chapter has a role that is very unique compared to the Chamber of Commerce, which people begin to ask, what is the difference between the Kenya National Chamber of Commerce and the International Chamber of Commerce Kenya Committee? And there's actually a very, very distinct difference between the two. The Kenya National Chamber of Commerce and Industry is exactly that. It deals with the trade operations and trade within the country and without the country, and also sorting out issues within the country itself in terms of trade policy, laws, and so forth. But the ICC Kenya Committee and the commissions that it is going to form, in fact we have 2 now and we are in the process of starting a 3rd one, our role is to pick up policy issues that need discussion at the international level, and that is done through commissions like this one. So when you go through your activities as the ADR and Arbitration Commission, and you find issues, this commission then works with the International Commission on ADR and sends those issues to them. They gather them and then say, we need to have some international order in this area. The people who then benefit from that particular activity is actually the chambers of commerce, who are the practitioners of trade. So that explains that, I hope that explains the difference between the Chamber of Commerce, the Kenya National Chamber of Commerce and Industry, and the International Chamber of Commerce Kenya Committee, which is the one I chair. We work together, and our roles are very, very specific. So we've also formed the Banking Commission, which is more around trade finance, and you'll hear a bit more about that. So the key thing is that this commission that you have here has got a lot of links into opportunities, not only for policy, but also for training. And I'm sure The man will talk about the ICC Academy and all those other places. So let me not. Oh, I see. Okay, I'm somebody else. Okay. So let me not take off. There's a lot of opportunities that being a member of the ADR Commission in Kenya opens up for you. And also being a member of the ICC in Kenya, also there's a lot of opportunities that open up for you. We have digital training that is opening up, which is run out of Singapore. For those who are in just general trade and are working within the ICC Kenya, there's a lot of opportunity that you can have in terms of development of yourselves. We are trying to grow the International Chamber of Commerce Kenya Committee. We are looking to grow our membership, and we're hoping that through having these commissions, we'll be able to grow our membership through the growth of membership within the commissions. And I'd like to thank Alim and his team for having led the way, and in fact our guinea pigs, as they succeed, we turn the lessons they've given us to the other commissions that are coming up. So I don't want to take up too much time. All I'd like to do is to thank you all for coming here and hope that you enjoy this conference for the rest of this day. I'll be here until lunchtime so we can interact as much as you like. And thank you all for coming in. And I hope that I will now able to officially declare this conference open and then invite our honored guest, Diamana Diawara, to come up and make her speech. Diamana, thank you very much. Please come up and address your people.
Good morning, everyone. So thanks to Patrick, I know I don't need to hold the microphone and you can hear me, right? That's great. Mr. Patrick Oba, Chair of the International Chamber of Commerce Kenya branch, Ms. Pascalina Kagunda, Secretary General of the International Chamber of Commerce Kenya branch, Mr. Alim Visram, Chair of the International Chamber of Commerce Arbitration and ADR Commission Kenya. Ladies and gentlemen, good morning. I am delighted to stand in front of you today in the flesh to address you. For those of you who attended last year, the first edition of the ICC Kenya Arbitration and ADR Days, you might remember that I had made the commitment to be in Nairobi in person for this second edition, no matter what. That's what I said in my concluded remarks. When making that promise, the only serious challenge I had in mind at the time was COVID-19. Little did I know that the burst of a war in Ukraine and the contested results of the Kenyan presidential elections before the Supreme Court, and I have to note there that you guys have your masters in Kenya of suspense in terms of political scene. I was far from knowing that all of these challenges were going to happen and that the already very changed world in which we were in September 2021 would be an even different one, even more different one today in 2022. So yes, I'm particularly pleased to have made it here today and have the opportunity to address you in person and meet every single one of you in person during this ICC Kenya Arbitration and ADR Days. The International Court of Arbitration of the International Chamber of Commerce is about to start the celebration of its 100 years in existence. A full centenary during which ICC Court has strived to support international trade by offering a safe, neutral, efficient, and always adapting platform for businesses, small, medium, and large, who are engaged in cross-border disputes, in cross-border commerce, to resolve their disputes. The history of the ICC Court is that of an institution made of leading practitioners in the field of arbitration and ADR around the globe, designing and implementing the best practices to provide a robust legal platform for its clients. And this translates into figures As of January 2022, the ICC Court Secretariat had registered over 27,000 new cases throughout its history. And you would be pleased to know that the 27,000th case, I'm going to be able to do it, was actually a case coming out of African countries. The preliminary statistics for ICC court activity in 2021 revealed that the Secretariat of the Court registered 853 new cases in total, comprising 840 cases in arbitration and 13 cases for appointing authority. The number is comparable but lower than the record number of 2020, where we had registered 943 new cases. In addition, the Secretariat of the ICC Court received 27 requests under the emergency arbitration provisions, which, if you don't know, are a procedure for urgent measures and conservatory measures that cannot wait the constitution of an arbitral tribunal. Early statistics also show a sharp increase in the average amount in dispute in new cases registered with the ICC between January and October 2021. With $184 million in dispute, compared to an average of $54 million for new cases between January and December 2020. For the same period, figures indicate that the median amount in dispute was similar to the previous year, $5.7 million in 2021, where it was $5.6 million in 2020. The amount in dispute in a single new case ranges from $9,500 to all the way to $27 billion. To quote the words of the president of the ICC Court, Ms. Claudia Salomon, our statistics illustrate ICC's ability to manage the full gamut of disputes, from large complex disputes to smaller ones involving lower amounts in dispute. When it comes to the African continent, the major trends to note is a sharp increase in the volume of disputes coming out of the economic activity on our continent. All aspects of ICC dispute resolution have grown in Africa over the past 2 years. ICC arbitration has registered an increase of 13% of the number of parties coming from Africa between 2020 and 2021. When it comes to mediation, the increase is much sharper, with a 166% increase in the number of parties coming out of African rights. Finally, ICC expertise services have also shown an increase of 50% of the number of parties coming from Africa between 2020 and 2021. In 2020, African states represented 40% of African parties involved in ICC arbitration. That figure in 2021 rose all the way to 50% of our clients coming out of African governments. A series of trainings dedicated to this particular group of stakeholders is currently being deployed by my department since January this year, with a very positive feedback. And the fact that African governments are so heavily involved in ICC arbitrations makes us want to work even closely with the legal staff of African governments to make sure that they hold the keys to the operations of ICC dispute resolution services. In 2020 and 2021, most of the arbitration cases registered involving parties in Africa were international cases. It is, however, interesting to note that about 20% of the cases involving parties from sub-Saharan Africa were actually domestic disputes. Such development of ICC arbitration in Africa, cannot and will not be done without African legal practitioners. That is the reason why the International Court of Arbitration has created, in January 2021, a department dedicated to supporting the development of arbitration and ADR in Africa, the team that I have the honor to lead. Thankfully, in Kenya, we count an ICC National Committee that has an arbitration and ADR commission led by Alim Visram, and that has been extremely active. This is one of only 6 national committees that ICC has in Africa. And I have to say, and I'm very glad to say, that it is the second most active after our ICC Nigeria National Committee. And I have a lot of hope for the future, having seen in less than 2 years the amazing work that has been accomplished by that commission. Building capacity for local practitioners and African governments' legal staff, identifying current legal and future leaders of arbitration and ADR in Africa, allowing those leaders to join the international arbitration practice are some of the activities that my department, ICC DRS Africa, in collaboration with our local branches, ICC Kenya among them, are doing on a daily basis. So I hope that with the discussions that we will have today about emerging trends in arbitration in Africa, the discussions that we had yesterday during our training on the conduct of arbitral proceedings and case management under ICC proceedings, many of you will see the interest in joining forces and joining ICC Kenya to become part of this great adventure that we have now started about 2 years ago, and that promises to be really great. I will stop my remarks here, but before I let the microphone and let our first panel start, I would like to recognize here 2 people without whom all of this work would not be possible. The first one being Lloyd Moniki, who is here and who's done an incredible job in putting all of this together for the ICC Kenya team. And the second person who is not here today, but I hope is listening online, is Sarah Duaka, my assistant in Paris, who is doing an incredible job to support me in this activity and this incredible adventure on a daily basis. Thank you very much, everyone.
Invite our panelists to come and take their seats. Welcome everyone, and thank you once again for being with us here today. I'd like to briefly introduce our panelists before we start. I know the word brief is alien to lawyers who still call a 100-page document a brief, but I will keep it brief. We have with us Mr. Professor, and most of you know him as the former Attorney General, here with us today. And of course, the IEBC team as well, as I hear today, but I'll go step by step. So Professor Mugai, welcome.
Thank you.
We have Jerry Kariuki, who is a member of the ICC Court, and I will say once again, that is the International Chamber of Commerce, not the Criminal Court. Welcome. We have with us Mr. Senior Counsel Kamau Karori, welcome. And we have with us Noella Lubano, who is a partner at Oraro as well. Thank you and welcome for being with us today. I'd like to start off this conference with a broad question, and I'd like to address it to you, Professor. What, in your opinion, do you see as being some of the most significant trends and shifts in arbitration and ADR across Africa? If you could share your perspective with us in about 5 minutes or so, we can then ask the others to contribute.
Thank you very much indeed, and thank you for inviting me yet again to this conference. I'll try to be very brief. As you've mentioned, it's very hard to be brief when you charge your fee by how long you've been talking. One of the most important and significant things happening in our profession, in my opinion, is the professionalization of ADR. When I started out a couple of decades ago, it was very informal. largely ad hoc, conducted by people who were not exclusively doing that, who were doing many other things. This professionalization, in my view, has improved standards and has created a sense of discipline. The second thing I see is the growth of institutions dedicated to our work. And in our region in particular, you see a lot happening in Rwanda, in Tanzania, here in Kenya. I think here in Kenya we are having some hyperinflation on institutions. We have this one, we have the Chartered Institute, we have the Nairobi International Center, and I personally believe we should be moving in the direction of creating synergies around this institution so that we all work together and harmoniously. And so should we in the region as well. I think we should have one serious regional institution bringing Rwanda, Uganda, Tanzania, Kenya, and all our neighbors. The second issue I think that has grown and improved our work is our relationship with the judiciary. Initially, the judiciary was part of the problem, not part of the solution. The judiciary had an attitude that arbitrators and mediators are doing work that should be done by the judiciary. I think we have won the battle of getting the judiciary to understand we are the same profession, we are doing the same thing, and we are achieving the same goals. And that has been a major success. Thirdly, I see the appointment of our members to regional arbitrations and international arbitrations as one of the biggest successes of my time, what I have seen. And I've had the privilege to serve in a number of international appointments. And I think that all the noise, for lack of a better word, all the noise we made over the last decade has resulted in some changes. And I think we need to keep making that noise. I am also very impressed by the number of young arbitrators coming through, meaning that the pipeline is good, so that when the senior ones, I will not mention them, when the senior ones retire, the pipeline is very good. We have a very youthful and vibrant, and I am also finally very impressed by the interest the academy has taken in our work. And here in Kenya in particular, I'm very impressed by the journal that is published, and the academics are getting very interested in what we do, and it's enriching our discipline. I'll stop there for now. I hope I'm within 5 minutes.
Yes, you are, Prof. And actually a follow-up question, if you don't mind, seeing as we still have a few minutes. What do you think the future of Kenya is in terms of it being a preferential seat for arbitration in Africa? Do you think we have good prospects at all, given the trends you've talked about?
Yes, I think that Kenya is in a unique position. As all of us know, the government has just put in place the Nairobi International Financial Center. And I think it's going to be a major center for encouraging investment and enterprise in Kenya and in the region. And we will be the gateway for commerce on the continent. I think we already are. And I see synergies between that center and our dispute settlement mechanism that is represented by the ICC, by the Institute, and by the Nairobi International Arbitration Center. So the future is, I think, is quite bright. We will come back to this question because I think it's important. The only thing we need to do, and I have spoken about this before, is to make sure that our processes are efficient. I worry about lawyers hijacking arbitration and mediation and converting them back to to a court structure and making the whole process inefficient, expensive, very formalistic, and so on and so forth. And the last issue, but maybe should be the first issue, is the integrity in arbitration. Because, if we lose that one, it's like a balloon. If we lose that one, then the entire system comes down. And our colleagues who work with us, commercial lawyers, corporate lawyers, they keep asking us, are you people still serious? Because we are beginning to worry whether we should advise our clients to have arbitration clauses or whether we should ask them to go to court. And that question is a serious question. I hope we can have time to discuss it.
Thank you, Prof. I will actually pick up right where you left off on that issue, and I can address it to Jerry Kariuki. Corruption is a big concern, and as Prof said, many people are trying to move back to litigation away from arbitration because of the concerns. Do you think we have adequate means to self-regulate as arbitrators and to self-discipline? Are we more or less vulnerable than other means of dispute resolution? What are your thoughts?
Well, first let us recognize that arbitration is a microcosm of the larger society. So perhaps we should ask ourselves, what is the society currently, what is it reflecting? And we have to accept that corruption is one of the biggest problems in our society. However, having said that, we as arbitrators, what position do we take within the resolution of a dispute? Everything revolves around us. Does that not therefore mean that we need to uphold integrity? So I think it's a question of personal integrity, first and foremost, okay? And then second, integrity of the process, upholding that integrity of the process. So we may need to go through a spiritual journey, asking ourselves first and foremost, what do I want from or to give? What kind of service do I want to give arbitration? Okay? Because that one bad apple, it can spoil that whole bunch for the people who come to us looking for a service that is failed or should reflect integrity. So corruption within our midst, please recognize it spoils it for all of us. Okay? So are we enough self-regulating? We may not be, but then does that therefore mean that we need to be regulated by an authority or something else? I don't think so. I think we need to take a good look at ourselves. Within maybe it's as I said, a spiritual journey that we need to take within our community of arbitrators and ask ourselves, which way do we want to go? Okay? Arbitration is confidential. Okay? But you as the arbitrator, ask yourself, what do I want? I've invested in myself quite a bit of money. And this is a service that I wish to give for a long time. So once corruption seeps into your specific arbitration, how long do you think you're going to last? At another ICC forum, I did give a story about even a robber wanting a person of integrity to hold on to their money, simply because when you go back for that money, you'll find every single shilling of your ill-gotten gains. And I had a person in the audience who came to me and said, you know, that story resonates with me because there was one person who took their money and gave it to a certain lady banker But when he or he went back for his money, he got 30% less. Why? Because the banker knew that the source of the funds was, they were ill-gotten gains, and therefore, who would he turn to complain? Now, do you want to be that lady banker, or do you want to be the person to whom that robber goes to and gives back every single shilling? Honestly, it's a question of personal integrity, but we need to ask ourselves again, which way do I wish to go and how long do I want to last? So, self-regulation, Alim, perhaps.
Thank you for that story, and that's a great example. I just want to also add, and for those of you who are new and you'll be learning about the ICC rules and you'll go through the training, we do have a code of conduct as well. We also have disclosure mechanisms under the rules which have to be complied with, and there is a declaration of independence and impartiality which all arbitrators or anyone who is being nominated as an arbitrator must sign prior to your engagement as an arbitrator. But the big question is, as Jerry put it, ask yourself who you want to be. And there'll be an opportunity for the other panelists to comment on one another's thoughts as well. But first I'll go forward and I'll come to you, Senior Counsel. Kamal Karori was one of the eminent lawyers in the Quartec mining case, which was a huge case for Kenya and for Africa. And so I'd like to get your thoughts. How do you penetrate the international market? How do you get into it and represent clients at this kind of a level? What are your thoughts, perspectives, and insights for aspiring arbitrators?
Thank you very much, Alim, for that question. I think the first thing I always say on this particular topic is that it's important for us to recognize, if we want to know how do you get into the international market, where are we, first of all? Because you cannot move forward unless you know where you are. And where we are is that we're in a situation where, as Diamana and others have said, an increasing number of cases are being generated from Africa. Why? Because Africa is opening up. We are getting more infrastructure developments being done, meaning that we're entering into contracts with people who are then doing the infrastructure. We still have significant amounts of mineral resources in this region. We are still developing our power sources and so on, and that it needs international support in most of these areas. There are very many contracts that are being concluded for the first time in which arbitration agreements are being entered into. That is one, and that shows that there is significant amount of business in this area that will generate arbitration or that will require arbitration and other methods of dispute resolution. And that means that there is sufficient amount of work that would come from this region. The danger with that is that if we are not careful, then we end up being an exporter of disputes to other places who then are the ones who will provide the dispute resolution services. So when we talk about how do we get ourselves into the international market, what is the international market? A lot of people, the perception they have is that I want to go and litigate in Paris, in London, in Washington, and so on. That's not the international market. The international dispute resolution market might very well be right here, so that if there is a dispute that has been generated, if there's a matter that requires resolution and that is the subject of an agreement between either different states or institutions or companies and international states or people operating from different states, which is the definition of international arbitration, those are some of the matters that we should be targeting. How do you target those kind of matters, and how do you prepare yourself to be able to be engaged in that area? The first thing that you must realize is that because we are talking about contracts emanating from Africa, it therefore means that African law becomes a significant part of that dispute resolution. And we cannot allow other people to be experts in, for example, Kenyan law. You should be very knowledgeable on Kenyan law. You should be an authority on Kenyan law. I find it strange when I go into some of these cases, like what you're saying, the Kota case, and I find that the discussion in the entire matter is about Kenyan environment protection law. And who is commenting on it? No Kenyan is talking about it. The experts that have been called are all non-Kenyan. And when you ask people, they will say, I was checking who can be my expert, and I can't find anyone. So we must be prepared to be experts, first of all, in our local circumstances, in our local laws. That's the first thing that we must do. The second thing that is important that we do is that in the preparation, and I'm happy that Mr. Obath and others are here, in the preparation of the agreements that we do from time to time, we need to be very careful about the dispute, the agreements that are entered into and the arbitration agreement that is crafted, so that we make sure that in terms of the appointment of items such as the place of arbitration, the institution is fine. I'm happy, Diamana, for us to do ICC all the way. Quite happy to do that. But where will the arbitration be done? Which is the place of arbitration? Which are the laws that will be applicable? Now, as I conclude and mention about Kotek, you'll realize that for the first time, the Kotek case changed the narrative about arbitrations emanating from Africa. Before Kotek, the only case that was referred to internationally on arbitration was the Kenya duty-free. And what is it about? Corruption. For the first time, we were able to argue a case and conclude it and succeed on the basis of respect for African and Kenyan law. And that's what we should be able to do. We should be able to defend our cases on the ability of, or on the context of the contract entered into, and not try and cry out and say, you see, we were actually being bribed, or there was some corruption that was involved. There must be a narrative that is different from what we have seen so far. Thank you.
Thank you very much, Senior Counsel, for those perspectives. One of the things that we are trying very hard to do at the ICC in relation to what Senior Counsel has said is prepare our people to be experts in their field, to improve their capacity, increase their capacity, and provide training. We are lucky that we have new technology, which allows us to do that from wherever we are in the world. And I'll take that straight to you, Noella. And I'll ask you to talk to us a little bit about the impact of technology. And as you talk about technology, I also want you to think about one more aspect, which I hope you can share with us. There's been a big buzzword around third-party funding. If you have any experiences in technology and third-party funding, we'd love to hear your thoughts.
Thanks, Halim, and thank you everyone for coming this morning to listen to us, and thank you for inviting me. I'm very honored to share this panel with all these eminent persons. Technology is a really big thing, and I find it very interesting because I know so little about it. But it's going to become very relevant as we go along, because the world is becoming what people say, it's now flat. You know, you don't need to cross borders to meet someone in another jurisdiction. You don't need to cross borders to trade with someone thousands of miles away. And so all our transactions, most of us are purchasing things online. So you're not walking into a store. And we all know that Tesla, which manufactures electronic cars, went online. So all its cars are now sold online, and so many other brands, Zara, among others. And so commerce and business is gradually heading in that direction. And what that means is that most of the disputes that we will see in the future will have this unique character of having been a transaction that was conducted on an online platform. And that comes with its own sort of nuances and difficulties and challenges. And so we will see online dispute resolution mechanisms coming up. They have already come up, and they're being overtaken by even bigger developments like blockchain, smart contracts, cryptocurrencies, NFTs, all these technological changes that are happening in the market. And what that means is there will be disputes. And these disputes will need arbitrators with experience, lawyers that understand coding, lawyers that understand how these transactions are conceived. They understand them well enough to be able to determine them. And so what I see emerging in the market is a new kind of arbitrator and a new kind of lawyer. A lawyer that is tech savvy and probably has a diploma or degree in coding. Because if the transaction is about a digital asset, it's a cryptocurrency, how are you supposed to defend your client? How are you supposed to preside over a dispute of that nature if you have no knowledge on the underlying contractual arrangement or contractual structure? If it's a smart contract, you need to know this is not a contract between human beings. There's no human intervention. You need to understand whether it's self-executing in terms of resolving the dispute. Is it on-chain? Is it off-chain? All these are terminologies that now sound very foreign, but they will be something that we speak about every day because, you know, we're going to the shops less and less. We're not walking into stores anymore. We're buying things online. You know, all of us are going to start having digital wallets. You know, we'll have digital currencies. So I do see arbitration developing or changing its character to suit all these new developments in the market. Another thing that's coming up that you've asked me about is third-party funding. And I think contextually in Kenya, it's still up in the air whether third-party funding is something that is lawful or it still contravenes, you know, the principles of Champerty. And I think that debate is outdated, but it is still the law. Common law still applies in Kenya. But what I have seen, at least in my experience, there are international arbitrations that are happening that are being funded by third-party funders, and the issue of whether these arrangements are legal or not, and where Kenya is a party, have not been raised, or if they've been raised, they've not, you know, the attitude of the parties and the arbitral tribunals have not been negative. So it seems this is an acceptable arrangement, and I just think one of the concerns about this is party autonomy and what are the stakes that the third-party funder takes at the end of the procedure, because the whole thing about third-party funding is to allow for access of justice for an otherwise impecunious claimant or respondent. But if that results in a third-party funder taking more than 50% of whatever is recovered in the litigation, or the third-party funder taking over the autonomy of the claimant within the decision-making process, or having a conflict of interest when it comes to settlement of that dispute, then there are all these problems that arise. But all these are new areas, they're exciting areas, and I guess my advice to me and to everyone else is to learn as much as we can about them, because the future is, the future is when technology and the law meet, then change is inevitable, and we must adapt or perish. So I think I'll stop there.
Thank you very much, Noella, for those thoughts. I'd like to move now to each of the panelists to be able to respond to one another's perspectives and comment, and then thereafter we'll open up questions to the floor. As Noella rightly said, we are looking at a new society with new lawyers, new emerging areas, and this is all very exciting. So let's hear what Prof has to say about everyone else's thoughts, perhaps any comments generally. We can go one by one, and then it'll be your opportunity to address questions to our panelists.
I'll just respond to Noella's comment about third-party funders. My concern is not that they are funding impecunious claimants who would otherwise not have justice. My concern is that you have this vulture funds buying litigation of some, exhausted claimants, and then coming to cause havoc in developing countries. And I think we've seen it in Zambia, we've seen it in God knows, I think only God has protected us here in Kenya. So we need to worry about that. I know in some countries, legislation has been developed to limit what third-party funders can do, and maybe that's what we ought to be thinking about.
Thank you, Prof. Jerry, your thoughts on any of the panelists' insights so far?
I know, Gidu, you said that you're excited about the number of new lawyers coming into arbitration and mediation, perhaps. My only request is, my only concern is that I need people to understand that arbitration is a very deep and very wide area, and that as you come in, because there's the attraction of the international level, as Kamau said. It can very well be in Nairobi, and especially with the changes since COVID, everything is online now. I want the younger ones who will eventually step into the shoes of Idu and I and others, that you take the time to understand deeply what arbitration is, so that whatever service it is that you're going to give to the clients, essentially that's who they are, that it will be service of quality. That is my greatest concern, because I think there are very many people who are in a rush. I've noted in the last decade, who are in a rush to come into arbitration, even into mediation, but they're just skimming the surface where knowledge and skills are concerned. So my plea is that do a lot more in terms of understanding the depth and the breadth of arbitration, and in terms of mediation as well, hone your skills and ensure that what you are offering is of the greatest quality possible. Thank you.
Thank you very much. Very important and wise words. Senior Counsel, over to you.
Thank you. I think I just make 2 or 3 quick comments. The first one is I agree that there is a lot of excitement about the continued involvement of Africans or emerging trends. But I just need to say we need to remember that while we were at some point pushing for involvement of more Africans in international arbitration and so on, what we were pushing to happen then has changed. The world has changed. The world has evolved and moved away from what it is we were thinking people would be involved in then. And so the point is that we should know that the world is not going to stand still and wait for us to be ready to get involved in international dispute resolution matters. We need to evolve probably a bit faster than maybe other areas are doing. I remember one of the books I was discussing with Prof. They say, you know, when hunters learned to shoot without missing, the bird didn't stand still. It didn't say I give up. What it did, it learned to fly without patching, so that way then it escapes the arrow. So the point here is that as Africans, while we would expect that people would look at us and say, you guys are just emerging, you're starting off, and therefore we'll give you some latitude as you catch up. The truth of the matter is that the world expects you to do that much better. The international arbitration community expects us to surpass the standards that are there now. So you need to do that much more than what you see being done out there. You need to catch up with the trends much faster than other people are doing. We need to be able to show not only are we able to do what is happening now in terms of the cases that are being litigated, we are able to do what he's talking about, cryptocurrencies and all these other things. We need to be prepared. So we shouldn't ignore the traditional arbitration and dispute resolution issues, but we must be able to know that the standards to which you are going to be held are that much higher than other people are held to. And to Noela's question about third-party funding, for policymakers and decision makers, this issue actually cropped up in one of the cases I was handling. And for government to be able to access those kind of services, there needs to be a lot of changes in procurement and so on, because you cannot be able to get someone to fund you unless some form of procurement is done. And then you also need to remember that from a political point of view, if Kenya wins, 100 million shillings, then 20 million goes to some guy. You might just see a demonstration, Malietu has gone away and so on. So those are some of the things that are the reality of the day that we need to take into account. Thank you.
Thank you so much for sharing those insights. Noella, your thoughts, comments?
Yeah, so I think I just want to talk a little bit about something that Njeri and Prof mentioned, and that's really about what I call the biggest problem I see in arbitration at the moment is actually rogue arbitrators, and just how to handle that scenario. And why it is even more important that we have this conversation is the finality of the decisions that they make, and the lack of an avenue to appeal what is likely to be a very impactful decision that has either been procured by corruption or fraud or is influenced by corruption. And it has, corruption in arbitration has many layers. It has whether the contract itself is corrupt, that's not what I'm talking about, whether the arbitrator is conflicted or corrupt, and then it also comes in how the arbitrator charges for that arbitration, and whether in doing so, I received an invoice with 702 hours of time spent on reviewing the paperwork. And I just thought to myself, how do I even go about, in block, not itemized, in block? And I thought to myself, how do I even go about trying to challenge this? What are my avenues? So I think it's a big problem. I think Jerry is more optimistic than I am about self-regulation. I think there's two types of people. There's a person that will feel some sort of conscious guilt when they do something corrupt, and then there's the person that just doesn't care or has accepted that as the norm, and that this is what the society has become and therefore justifies those actions. And I think if this person B is left to self-regulate, then we might have a problem. So I think there's a lot we need to look into that. And then the second issue that I know another panel will deal with, but I think is an important conversation, is just the number of women who are getting into arbitration and who are leaders in their own right in that space. And for me, that's very encouraging. There's a lot of young women, older women involved in arbitration. And I like telling people this because it's a favorite phrase I use this year, is that the future is female in arbitration. Yeah?
Just weigh in for a word. I'm the only one, I think, who has not spoken much on this issue of corruption. So let me just comment on it. So I have 3 points. The first one, I think Prof has had it before. I have always said that people are not corrupt because they're African. You are corrupt because you're corrupt. That's your character. And I think it's important for us to always come from that point of view so that we don't always feel that we are carrying this weight of does everybody think that I'm corrupt? It's important for us to still send the message that there are people from here who are not, but there are very many, there might be others who are corrupt. So that's, I think, is an important one. But secondly, I think we need to distinguish what corruption is. There is a corruption of somebody who is bribed and takes money and so on and so on. There is that one format. There is the other who, because he completely has no idea what it is that he's doing, he's easily influenced by all manner of circumstances. And then, of course, there is the outright person who is just corrupt, right? So institutions such as the ICC and others, I think, must develop ways of I'm not saying, regulating them, but identifying people who from reputation and from the work that they have done are known to be able to deliver on what they are required to do on time without being influenced and without being corrupt. I think it's important because it is the only way in which you can be able to say, if you give us this huge brief, I know that if that matter is given to X, as ICC and as a country, we are sure that that matter will be handled and will be handled well. And then that person is expected to mentor or to also, deal with other upcoming arbitrators so that you pass on the baton. Because the problem is that you have all these good arbitrators. When they move away, when they retire, I don't know why, Gitu, you are suggesting I'm also retiring. Not yet. So, oh, you didn't say, yeah, I saw, but him.
He mentioned both of them.
So we need to have the next group of people that will also be able to handle these matters and with a reputation built around the fact of who mentored them and how they worked under that mentor. So that the mentor can be able to say, I'm confident X can be able to take up the role and not to be influenced or induced in any way. Thank you.
There is, if I have your permission, there is a very dangerous trend that is creeping slowly into our profession, where the arbitrator may be manipulated without being complicit. Because what tends to happen is that you have two advocates, two lawyers representing a matter, who then want to use the arbitration as a forum for consenting. Okay? So they purport to file the claim, then purport to file the response, then purport to file the counterclaim, then to frame the issues, then they purport to agree. There is a settlement. The claim was 1 billion. Now they say, now we have agreed on 500 million. Now let us sign a consent. Now that is the most dangerous, and that is what we should be looking out for. If parties want to consent to settle a matter, they don't need the arbitrator. They just need to sign an agreement among themselves that they have resolved there. Why do they need the arbitrator? Because they are trying to sanitize what is otherwise an irregular settlement. I hope if I haven't contributed anything this morning, that is of some use.
Final comment. I'm sure you've heard, all of you, about a certain case that came through where the courts are purporting to regulate arbitrators. That is another dangerous trend. And I'm not sure how we're going to deal with it, but I think there's another level of sensitization that must occur as far as the judiciary is concerned, because my recollection of UNCITRAL, why that law was developed, was because the courts had to be removed from arbitration. We have our own Section 10, and we must move to having the courts out of arbitration and not allow them to regulate the process and of arbitration at all.
Thank you. Very interesting and practical examples of situations that we all need to look out for as young arbitrators or perhaps even experienced arbitrators. I'll just weigh in with my own thoughts on what they've said and then open up the floor to questions. I think, as Professor rightly said, we must be aware that parties may use the tribunal for their own means, and it brings up questions for you as a tribunal. What do you do in such a scenario? How do you handle it? Do you still go ahead and do an award by consent of the parties, or do you simply ask them to consent on their own so that you are not manipulated? It's a situation that I think many of us may face in the future, and it's very important that he's brought it to our attention. If we are to encourage Kenya as being an international seat for arbitration, we also have a huge responsibility, as senior counsel said, to be the best that we can be. We need to develop our skills, we need to educate ourselves, we need to have good ethics, we need to have good morals. We need to make sure that when people come to Kenya and they choose it as a seat, they have confidence in the society and the people that form the Republic of Kenya. And I think that's also definitely worth noting, as senior counsel has brought to our attention. As Noella rightly said, arbitration is changing. We are moving into a field that is unknown to most of us. The technological advances are an area that we as lawyers and arbitrators must also catch up with. We should understand what third-party funding is. We should understand how some countries are using legislation to make themselves a more attractive seat of arbitration, such as Nigeria. We might have to find a way to catch up with other countries as people, but also as a government, and we have a role to play with our stakeholders there. And as Jerry Kariuki rightly said, we also have a role in ensuring that the process of arbitration is not unduly supervised by the government to a point where we lose some of the unique aspects that make it an appropriate medium for resolution of disputes and still confidential for the parties. So there's a lot to think about, a lot to protect, and a lot for us to do. I will open up the floor now to any questions. Shiko can provide a microphone to whoever has a question. And I see that our director of ADR from Africa has the first question. So Diamana, you can take it away. Willie Mutubwa is also with us, my apologies. because we did not see him on the screen at all. Before I open up questions, I will ask Willie Matubwa, who is the chairman of the Chartered Institute of Arbitrators, to share a few perspectives with us. My apologies, Willie, we didn't see you, but now that we do, we are very happy you were here with us. The theme of the conference is emerging trends in arbitration across Africa. And as the chairman of the Chartered Institute of Arbitrators, you have many, many disputes that come before you where they are seeking the appointment of an arbitrator. In your opinion, which area is attracting the most disputes? And which area do you think arbitrators need to look out to, learn a little bit more about, and perhaps consider as an emerging trend?
Thank you very much, Alim. I hope you can hear me. I want to thank you once again for inviting me. Unfortunately, I was not able to attend in person. We are launching our Uganda chapter this afternoon in Kampala. We are very excited because the Chartered Institute once again proves to be a leader in this area. I want to say one or two things. I think my colleagues have said enough in terms of the challenges, the prospects, and the future of arbitration. As an institution, one of the things I see as the future of arbitration is collaboration and partnerships at the center of our interaction. I see arbitration remaining strong. My experience leading the institution shows that there is a sustained growth and confidence in what we do generally as arbitrators. I have listened to some of the issues raised by the panelists, particularly on the question of rogue arbitrators, corruption, and the like. One of the things I always find myself reflecting over is when I meet arbitrators, when I meet party representatives one-on-one, there are complaints, pockets of complaints about the conduct of some of our members. There are pockets of complaints about some courts and some practitioners in the area. But I never get to exactly get complaints or see complaints brought to the institute. And perhaps, Alim, from your end, you may also, because you run this institution from the ICC in Kenya. Many people speak about the challenges, the problems that come with rogue arbitrators, perhaps corruption. But it is all said, because I will tell you, for the last 1 year and a half that I have been chairman, I have not received a single complaint about any arbitrator in any particular form. Sometimes the problem is people speak about perceptions and they are not willing to put themselves out and say, this is where the problem is. I think it is important that we now move and we are bold to address the issues so that we have, as Alim has said, we have a code of conduct, we have members whom we can discipline, whom we hold to account. And I think it is important that practitioners also come out and give us details of some of the complaints they have. I have seen other people who complain largely because of the manner in which a matter has gone and not necessarily because they have a specific complaint against the arbitrator. And I think we must then move to the next level as we develop ourselves into a regional hub. I am one of those who believe that legislative intervention may help. It may help because the community has grown. When I joined the institute, we were hardly 100 members. Today, I lead an organization with at least 1,200 members. With growth comes many of those challenges. And these challenges have to be met in a manner that is objective, in a manner that is also sustainable. And I think the future, in terms of ADR and dispute resolution generally, is to look at integrity, sustainability, and specialization. Sustainability for the organizations, because I think what is important for us is to ask whether we are able to sustain the growth meaningfully going into the future. Time has come when we should start having, as Noella has said, arbitrators that are skilled in certain areas, specialized in certain areas. What we have done as a Chartered Institute is we have expanded our approach You can see we are now in Uganda. We are trying to set up another chapter in Tanzania to present opportunities to our members, particularly in the area of international arbitration. Perhaps we may want to start thinking about administering some of the disputes that come to us. Ad hoc arbitration comes with that shadowy problems of charges which are not clear. Is it time that we consider perhaps having options of administered arbitration, even domestically, in some of the areas we have been working? I want to finish by saying that the role of professional organizations is to peer review and keep each other in check, improve the skills of our members, but also to mentor. There is a very strong mentorship process platform in the Chartered Institute. I know that the ICC has also a very strong mentorship program. Some of the vices, some of the challenges we are seeing is related to what people see as shortcomings in our mentorship programs. We have many people who desire to become arbitrators, but who do not want to invest the time, the energy to learn the skills under the tutelage of our senior colleagues. So I think one of the areas that we need to start looking at is mentorship at a more specialized and strategic level, and that will help us move forward. Many of the other things have been said. I want to thank you, Alim, and congratulate your team for putting together this second conference. I know how difficult it has been, but under 1 year of existence and doing this, this is great. And we at the Institute will support you all the way. Thank you.
Thank you so much, Dr. Mutuba, for those valuable insights and advice. The Chartered Institute has been an incredible partner for ICC Kenya Arbitration Commission. And we have a lot to learn from them as the prominent institute in Kenya right now that handle majority of the arbitrations. I hope you will stay with us for a few minutes, Dr. Mutuba, in case there are any questions addressed to you.
Indeed.
Thank you. At this point, I'd like to move back to the audience. We still have a few minutes. You may never see these panelists again. So if you have any questions for them, now is your opportunity to raise a question or two. Shiko has a microphone that she'll be able to pass. I already see a question from Jajangawa.
Good morning, everybody. My name is Mary Angawa. I actually would like to make a comment. And I think the most important aspect is what my professor raised, and that is corruption. Unless we address corruption in our society, we will never, ever achieve our goals as fast as we want. And there's a saying that when a fish rots, it begins at the head. So we need to examine ourselves as leaders as to how our integrity is, and we must make sure that we do not entertain any corruption. And I'd also like to make that comment about how advocates, having probably failed in the courts, has creeping into arbitration. And when they have crept in, they are bringing some of strange habits that were never there. I know that our Chair Mtubwa has said before that when somebody comes for arbitration, they say, oh, the arbitrator should declare they should not participate in this case. They should declare their interest or something like that, or disqualify themselves. They disqualify themselves, and that case will go back and forth 8 times. What do we do with such a situation? We need to arrest it somehow and to bring back the integrity and not to allow it to creep in. We are seeing small little snippets of it, but we need to nip it by the bud. So I would really appreciate what the Professor Mugai said about the aspect of there's something wrong sometimes in arbitration. and we as arbitrators should be very sensitive to those kind of aspects. Thank you.
Thank you very much, Judge, for that helpful advice and comments as well. I see there are questions on the screen. Would you like... Yes, there's a question from Diamana.
Thank you, Professor, for noticing me. And thank you to this panel for an excellent conversation, very engaging. I have a couple of questions. I promise I'll be quick and comments. I would like to pick up on a point that was made in his remarks by Professor Mwigai on the fact that there is a risk or a concern that the practice of arbitration slowly turns into a repeat, probably a bad version repeat of what we see in litigation. And I think that's a very, very live concern, not just in the practice on the African continent, but more largely in the arbitration global community. And just earlier this week, I was at the Congress of ICA in Edinburgh, and we were discussing progress made in arbitration left to be made. And clearly, when you look at the costs of arbitration for parties, how much is charged to those parties, and when I talk about that, I'm not talking about arbitrators or about institutions. We're talking about counsel fees, because that forms part of about 85%, if not more, of the cost of an arbitration, generally speaking. I think there is room for us as a community of practitioners to be careful the way we charge our clients and what we put in those costs that we make the parties carry, because the end result is that it's going to drive them away back into litigation, which could be fine if they could find everything they need in litigation. But the premise of the conversation is that arbitration was bringing an alternative and a positive one. So let's not turn into something that we were trying to fix, right? The second point I wanted to pick up on was made by Senior Counsel Karori on the robustness, or the visibility and the knowledge of our practitioners and of the knowledge of our laws generally in Africa, and how that discrepancy between the local scene as opposed to how in international arbitrations, local practitioners would not necessarily be represented. And interestingly, the point on place of arbitration has been one that within the ranks of the ICC, having been a counsel in ICC Secretariat team, has been a very heavy point of discussion on and on with the court. And Jerry here can tell you, when the ICC court has to fix a place of arbitration in a case that involves African parties, ICC Secretariat would brief the court and try to bring elements objectively, and when it's, in my case, when it concerns an African, a case with African parties or with African elements, I would try to advocate when it's appropriate for an African place of arbitration. The truth is that often we're faced with lack of information or lack of access to the information, and there comes into play the role of local practitioners. There needs to be more writing, there needs to be more legal authorities out there on the practice of law generally and arbitration more specifically in Africa, because it's difficult, and I'm not excusing the lack of diversity or diversification of international arbitrations, but it's difficult for institutions to feel confident that if I fix Nairobi, Kenya as a place for arbitration, the parties in my dispute will not face difficulties the day they have an award in hand and they need to enforce it. If I don't have information as to how Kenyan courts treat the awards, what are the past decisions in domestic arbitrations? It doesn't have to be with respect to an international case, but how have the courts positioned themselves as to, conflict of interest, as to the validity of arbitration agreements? So lack of access to these fundamental points in international arbitration is one of the very important reasons why it's African seats, I would say, don't have the recognition they deserve. And of course, we know there are safe seats. And some countries, Rwanda, for example, they do an incredible job at actually advocating and making visible the decisions that come out of the ranks of their courts. And that's the way we should go. That's the way our jurisdiction should go. Our legal practitioners should go, is to write, make public, share knowledge about how arbitration decision cases are being treated in local courts. I'll come to a question, I promise, and that is concerning corruption. And I'm happy to have heard Dr. Mutuba talk about this distinction between ad hoc and institutional arbitration. And my question, picking up on his point to all of you here, because you've all addressed the point of corruption, is precisely whether you don't think that by going more towards institutional arbitration, maybe that's where the key is to solve that question with respect to corruption, because we know that when there's a third neutral, and that's the institution looking over the shoulder of the arbitrators and the parties, there's less room for these things to happen. Obviously, it doesn't evacuate them all. ICC has currently commissioned a task force going on issues of corruption in international arbitration. And the reason why we have this task force going on within the larger Commission on Arbitration ADR is precisely because it's a very live question, even outside the African context and even in international institutional arbitration. But then the question is whether institutional arbitration doesn't present an additional safeguard compared to ad hoc. And I'll stop here. Thank you.
Thank you, Diamana, for those questions. I'll allow the panelists to respond one by one. Perhaps we can start with Dr. Mutuba because he's joining us via link virtually, so that we get his perspectives and thoughts, especially since we left him out earlier on. Dr. Mutuba, I invite you to respond.
Thank you very much. One of the challenges you get leading an institution is that you have to deal with people with varied or various objectives in joining the organization. Just as Njeri has said, we have a community of people who want to do the job and do the job very well. We have some people who also come into the community with other objectives. The job of leaders like ourselves is to create an environment that gives confidence to the users of this service to know that they can trust our people. I always tell arbitrators that seated in your boardroom, in your private confidential proceedings, you are the face of the 1,200 of us. What you do in that room impacts on what I am doing in my own room. So it is not just about the individual, but it's also about the collective approach. We try our best to ensure that right from the training, we inculcate those principles of integrity, ethics, moral uprightness, but we may not always get it right. My thinking is, and where we sit as the institute, particularly as a branch, we look around and we see some complaints coming through. Many times people just complain when we meet in conferences or when you meet on the streets without any specific particularity. But we conducted some research last year. One of the things I would say is that the popularity of arbitration, both domestic and international in Kenya and the region, is on the upward. Today we are in Uganda. We have just trained about 40 people in arbitration. They are taking their oral exams today. In a short while of about 4 months, we have had at least 70 people joining from this country alone, joining the family of the Chartered Institute. It tells you something. When I started as chairman, the number of appointments we were making every year, and remember we are default, was about 190. Now we are pushing towards 300 this year. It tells you that people still have trust and belief in arbitration. What we need to do is to ask ourselves whether we are doing enough as a community to make sure that we do not lose this trust. Because building trust over 40 years is very difficult, but losing it can take less than 6 months or 3 months. But again, about self-regulation, the question of self-regulation and whether we need some intervention because of the various players in the space. Today, when you look at mediation, for instance, we have over 10 organizations purporting to train mediators, to certify mediators. What do we need to do so that we can maintain a standard, an approach, a level that we can all say is the level which we must operate under? And I think self-regulation is the best, and we must get together. I know that organizations such as the Nairobi Center for International Arbitration, the ICC, ourselves have had these discussions many, many times. And as my senior, Mr. Karori, said, at the end of the day, it is about individuals. But what I see as an institution is that the individual character of persons impacts on the general profession itself. And that is where the focus should be. I have seen statistics showing that where you have a court or you have another level of intervention or perhaps scrutiny, whether it is a court, whether you call it a council, it helps reduce the perception, because some of these are perceptions and some of them are realities. So how do you draw the line between perception and reality? You must have something which you defer to, all of us as practitioners in this area. And I want to encourage people who represent party representatives, parties who appear before arbitrators, to come forward and speak about their experiences, make reports. What we have now started doing is to also write to our arbitrators, even in ad hoc arbitrations, to receive feedback on how long they're taking to finish matters, what difficulties they are facing, if they are seeing any area where we can intervene as an organization, as a professional body, to assist in moving matters forward. One of the other problems we see, Alim, is that arbitrations are now taking up to 6-7 years. Parties are also frustrating arbitrators. Some are trying to intimidate arbitrators, including using police and suing arbitrators. It is almost certain that if an arbitrator sits in a matter, is likely to be taken to the High Court on the slightest of provocation. I have had 2 or 3 cases where arbitrators have been asked to write statements in police stations on fairly frivolous grounds sometimes. And I think the conduct of advocates trying to win matters by all costs sometimes also undermines this process. I have also seen arbitrators who are very weak, I must say. You appoint somebody, he withdraws from a matter. You appoint the next one, he withdraws. There are 2 matters which I have had to appoint arbitrators 9 times in 1 year, because on the very slightest provocation, an arbitrator is withdrawing. And arbitrators, I want to encourage arbitrators that when you take the office of arbitrator and you put your foot down and you are doing the right thing in good faith, exercise your office objectively, fairly, but also without being intimidated. I am sure some of you have some of these stories, but I want to just say my view is we must also look out for each other. We must also prepare arbitrators who are able to do the job, even in difficult circumstances. Thank you very much. Back to you, Aline.
Thank you very much, Dr. Mutuba. Because we're short of time and actually coming to an end, what I will do is I will ask all the panelists to respond to the questions raised by Diamana. And also there was one other question on the screen, so I'll ask you to respond to that as well, which was, given the concerns relating to arbitration, should we publish awards? I think I've summarized that question based on my 5-second glance of the screen. And as you also address those questions, you may want to make any concluding remarks as well, so that by the time we get to the end, we can then allow the next panel to come forward. Thank you.
I want to agree with Madam Director that institutional arbitration does provide a layer of protection from capriciousness. And I personally would favor that as much as possible. Secondly, I think that we must find a way of having an enforceable ethical code within our institutions and sharing it across the Institute, the ICC, the International Center, and so on. And the truth is, my chairman has said that many people talk in the streets, but the streets also create evidence of that is actionable. Because if an arbitrator is mentioned twice, thrice, 4 times, we should have an informal way of saying this person can no longer be acting in the name of the institute. Those will be my 2 comments. As to whether awards are published, there is so much controversy about that, partly because of the confidentiality of the award itself. I would be in favor of not publishing.
I'm going to answer that last question first. I'm not also in favor of publication of awards, unless, of course, they've been through the High Court. I mean, that once they're in the public domain, and they've gone through enforcement and perhaps have been challenged, so on and so forth. So long as they're in the public domain, I have no problem, but not like in an ad hoc level. And without the party's consent, you cannot publish an award, and I think I'd prefer to stick to that. There's something that Noella said about receiving for perusal, pure perusal, 702 hours. That's a bit long. And I just thought to respond to assist you in that, perhaps you should look for their timesheets. I don't know if that would assist, because before they get payment, perhaps you should take a look at the timesheet and then question, because 702 hours for perusal. I was trying to figure out how many days that is, and you're not going to be spending every minute of every day perusing documents, and of course, unless there are piles and piles and piles, and you're not going to look through everyone. So, just taking that and saying, really, the answer is personal integrity. Okay, we cannot say it enough. Yes, we can talk about regulation, and yes, the market will weed out rogue arbitrators. But what kind of damage has that rogue arbitrator done? First, to the parties who are looking to him or her for a good arbitral award. Okay, and number 2, that bad apple, what impact has it had on the view that society has of arbitration? Okay, so yes, Chairman, I agree with what you've said, but we have to push this business of personal integrity. We really must. Third, I think there was the question that Diamana asked, and I'm associating myself with the remarks that Gidu has made. Yes, it may add a further layer of protection, but ultimately, personal integrity will be the solution. Thank you.
Junior Counsel, over to you.
Okay, thank you. The good thing of coming as a third speaker when your teacher has spoken, you don't have too many things that you want to say. But let me just say this: I agree that one of the biggest challenges we have is that corruption, by its very nature, is a private sin. The only people who know that corruption has occurred is the person who has been compromised and the person who compromised him. Those are the only two. So the rest of us can only speculate as to what might have gone on, and so providing evidence becomes a problem. But I think that if we deal with institutions, and if we do typically like what ICC does, where there is a court that then looks at the award before it's published, some of these ridiculous awards would be weeded out. I'll just give you an example. There's a matter in which we are challenging an award. If you read the award from the beginning to about page 80, you can see where it is going. Then suddenly at page 89, it takes a twist. And you try to marry what he has said before and what the outcome is. And you can see, I think the approach was made at paragraph 89. That's when the person was seen. So in sort of those instances, if there was someone who looks at that award, probably they would have been able, they would have arrested it. And two, I think even the conversations we are having here, if I sit with Professor and I sit with Jerry and we are addressing you, and I know what Prof thinks of me, and I know what Jerry thinks of me, I think I'll be more concerned because we are in the same institution, we are dealing with the same rules that have been promulgated, and so there is a peer pressure on me to also make sure that I have of equal standard. And so, and as Prof rightly says, the street has evidence of everything that, that is going on. So if you want to protect your name, your integrity, then having institutional oversight and the fact that you are prepared to have somebody who can look at what it is that you are doing, not changing your decision, but can just look at it to see what it is that you're working on, means that even you are confident about the integrity of the document that you have prepared. Thank you.
Thank you. Noella?
So just some quick comments on reactions on what has been said. With regard to the question of whether awards should be published, I don't think they should be published, but I do think awards that involve states should be published, because I think the citizens of that state have an interest in what the government has been doing, and I don't see why there should be confidentiality in government commercial transactions. So that would be my rider. With regard to corruption, a lot has been spoken about it, but I think the thing that we need to understand, and someone needs to articulate this very clearly for all of us, is what are the enforceable mechanisms available to hold an arbitrator that is genuinely a rogue arbitrator accountable? Whether as a matter of raising, overcharging, or whether as a matter of being compromised, or whether as a matter of being conflicted but refusing to recuse himself or herself. I think those are very important questions, and they may be street whispers, but I think at some point we need to be able to answer these questions. Then finally, to the question by Madam Chair, institutions mitigate the risk of the appointment of rogue arbitrators, but I do not think they eliminate that risk. There are some institutions, and I'm not speaking of the ICC, where the corruption is in the institution itself. So I wanted to use irregardless. I don't think that's an English word. I'm not sure it's an English word. But, so irrespective of that appointment having been done by an institution, if that institution itself has a problem of corruption, then the appointee will have the same problem. So I think they do not eliminate, they probably mitigate, and it depends on which institution we're looking at. I think those will be my closing remarks.
Thank you very much, Noella. Thank you to all of our panelists for taking the time to be here with us today for a robust, exciting, and very engaging conversation. I know that we'll all benefit from their perspectives and their insights. Thank you all. I'll now invite you all to leave the stage and hand over back to Shiku.
Okay. Thank you, Alim, and all of your panelists. Okay, I think it's about time to take a break. I can see a lot of people looking like they're dipping in energy. So we'll take a short break for tea. There's tea at the back. But what I would suggest we do is if you can get your cup of tea and your snack and come back, and then we can continue with the second panel, because I think we're running a little late. So before we do that, I just want a little more housekeeping. So the washrooms are to my left. There's a door to the left, just outside there. There's a green screen behind that. You'll find the ladies and the gents. And for the next sessions, I think the next panels, we're not going to have a live Q&A. What we're going to do is we're going to use Mentimeter to where you can type in your questions, and then we can project them, and the panelists can then answer them. So Yeah, so what we're going to do is we're going to project how to use Mentimer on the screens during your tea break. And then in the next, I think, 15 minutes, I will come back and call you all to order and we can continue. So enjoy your tea and yeah, see you in 15.
This one is 2 bars. This one is put it over here. Niko naomba. Oh no, this is. Which one? This one. Hello. Hello.
One, mic check 1, 2. Mic check 1, mic check 1, 2. So let them pick the levels as they are speaking. I'm just speaking to it.
Hello, good morning, Alfred. Can you hear me well?
That's the challenge. I was asking if they have a lapel.
I have one here.
Can we do?
It's actually here on me.
Yes, no, it's fine. For him, it's fine. Okay. But we need
a little bit higher.
Tie. Is it better under the tie or top of the tie? It's okay here? I'll ask you to be a bit of a distance because of the knots. I'll hold it for you. Microphone check. Microphone check 1. Microphone check 1, 2. 1, 2. Is it picking on your mic? Microphone check 1, 2. Amna ta receiver ile yenyu. Levels ziko sawa. Levels are good. Feedback ya hiyo generator iko juu ama kidogo? Very good. Alim, good. So tell me where you want to a little bit in front. Yes. You need me left or right? Am I better here or the other side? No, me I'm not. It's on news. Yes, I'm not in. It's I'm tuition. You're good. So Alim, just introduce. Okay, which means I use my left hand. Yeah, so ignore them, assume they're not here. So I'll prompt you the question. Sure. Please, thank you. Good. So thank you very much for joining us. Just tell us your name and what you do.
Thank you, Alfred. I'm the President Chairman of the International Chamber of Commerce Arbitration Commission. I'm an advocate and the principal founder and lawyer of Visram and Company Advocates.
Very good. So today we are having the conference, the second annual conference on arbitration and ADR in Kenya. Just tell us what this is about and the significance of it.
Sure. So our conference is about emerging trends in arbitration and ADR across Africa. This is fueled by the cross-border disputes that we have today, investment and infrastructure projects, and essentially the fact that international arbitration is now here with us in Kenya. Our goal here today is to bring stakeholders, private entities, lawyers, and arbitrators from across the country so that we can improve the capacity of Kenyans to be involved in international arbitrations. We can engage with stakeholders and entities, and we can find a way to make arbitration suitable to their needs. That was the purpose of today's conference.
For someone who doesn't know much about ADR and arbitration, give us a brief introduction. What is it, and how big is the industry in Kenya?
Sure. Arbitration is now an alternative to court proceedings. And there are many other types of dispute resolution, but I will talk about arbitration. I will say majority of cases now end up in arbitration before they get to court. And the reason being is because almost every international agreement or any agreement has a clause that requires parties to first seek to resolve the dispute by way of arbitration. What that means is that they get to pick the judge that they want. They get to pick an expert in their field who has the relevant skills and who is able to meet the criteria that they require specific for their dispute. That is really the essence of arbitration.
Looking at the markets within Africa, within Kenya, what can you say compared to the global sector, the global industry?
The market in Kenya for arbitration has expanded drastically. We are about 10 times bigger than we were 5 years ago. Majority of cases, as I said, go to arbitration. We also now have major international commercial arbitrations taking place in Kenya because of the various disputes in infrastructure, because of the investment that's coming into the country, and because of the huge proliferation now of international institutions in Kenya, ICC Kenya being one of them.
We need some quiet, please. Yes. Manage that noise for me. That noise. The laughter. Get them not laugh. Someone. Very good. We have to get it perfect for team. So let's talk a bit about the trends that we've had today. What are the top 3, top 5 that we are discussing? And what are the likely impacts in the sector?
Okay. So 3 of the trends that we've talked about is now essentially with infrastructure projects and major investment in Kenya. The fact that arbitration is here and that we have international institutions, how do we penetrate that international market? How do we as Africans, how do we as Kenyans get ourselves on that international stage so that we can show the rest of the world that we have bright people who have merit and can participate in these arbitrations at a very high level? That was one of the discussions we had, and Senior Counsel Kamau Karori led that discussion. One of the other issues we talked about, which was actually presented by the former Attorney General and Senior Counsel Keith Mugai, was the fact that now arbitrations, unfortunately, are replicating litigation proceedings, and we need to be true to the essence of arbitration and find ways to resolve the disputes quickly without replicating litigation and arbitration. A third trend that we talked about that is happening right now across the world and how to get over it is the big C corruption. How do we as arbitrators self-regulate adequately? How do we put into place mechanisms that will allow us to carry on this means of dispute resolution and still build confidence of society and our mandate as arbitrators?
Very good. Finally, in terms of opportunity, obviously we're talking about business, we're talking about disputes. What are the opportunities that exist for private sector, be them corporates, be them individuals looking for ADR or arbitration solutions, or even within the legal fraternity itself? What are some of the opportunities?
There are tremendous opportunities to engage in arbitration today. We provide training on a regular basis. We have actually had 3 different training courses in 1 year alone, where we are teaching people about the process, how to engage in it. We're helping them understand how the rules work, and we're teaching them how to actually be arbitrators as well as to write awards. These trainings go beyond ICC Kenya, and there are many other institutions doing the same thing, such as the Chartered Institute. I think that today in Kenya, if you want to be an arbitrator, you're in the right place at the right time, because everything is available to you to take up that opportunity.
Very good. For the business sector, for private sector looking, for different ways to resolve their disputes, what can you advise the sector?
I would advise the private sector to have confidence in mediation and arbitration. I would say to them, insert a clause in your contract. Make sure it's not a last-minute clause. Make sure it's not what they call a midnight clause. Take the time to understand what arbitration is. Put a clause in the contract that works for your dispute, that you are comfortable with, and that will actually be of use to you in the event you have to resolve your dispute, so that you can still maintain amicable relations with the other side. In a scenario where it's not necessarily a zero-sum winner-takes-all, try mediation. You can save money, you can save costs. Try arbitration. You can pick the right person that you think is most suitable to your dispute. Great.
Thanks a lot. Cheers.
Thank you. Cheers.
Let me talk to Diamana. Very much. Good. Yes, that's for him. Michael's good. Yeah. We pick Diamana. Diamana or Karori? Wow. Let's get Diamana. We can talk let's get him. But we didn't have much content. Yeah, because of time, let's just get the news value.
Sawa.
No.
Oh,
this is Kepsa content. Yes, and from here we go to cutting. What did Jamaliza?
Yeah, I know.
Yes.
We just need a picture. Please, do us the honors.
Thanks, Ali.
Thank you so much.
Let me do this first. Good. So advise me where you need her. You could left, right? Yamana?
Yes. Do you need me to remove this, maybe?
Let's use that for our microphone.
Okay. That makes sense. It's about to start. Are you aware that we can hear in the...
Sorry about that. Because we're using the same, just pull your tag down a little bit.
Okay.
Your mic yako, is it better? Ama tuweke kwa nguo. Tuweke kwa nguo, yeah? You just put it on what do you call it? Your collar?
Yeah.
Yes. Somewhere there.
Okay.
And play this. You know that.
Do you want me to drop it? Have it in my hand?
Let's let me hide this behind you. Sorry about this. This is now production. Yes. Sorry, my hands are a bit cold. My apologies. The cable on the canal, that works for you? Very good. So I'll prompt you.
Okay.
Myself, she's okay.
So I don't know what me. Okay.
Yes, I'll prompt you, don't worry.
Can you just tell me what questions you asked me?
Yes, I'll pick a little bit from your speech.
Okay.
Some of the numbers, statistics about cases in Africa.
Yes.
We talked a bit about integrity issues.
Yes.
Still bogging that down as far as guilt is concerned. Where are we in that conversation? And of course, the significance of the conference in Kenya today.
Okay.
So, but the questions will just flow based on your responses.
Okay.
So don't worry about it. We can do, one take. So just relax, take your time, don't be in a hurry.
Okay.
Yes. You good?
Yeah.
Thank you very much for your time. Just introduce yourself and tell us what you do in ICC.
So hi, I'm Diamana Diawara. I'm the ICC Director for Arbitration and ADR Services in Africa.
Yes. We are at Movenpick Hotel for the second annual conference on ADR and arbitration in Kenya. So what is the significance of this conference today?
Yes, this is, so as you said, the second edition of the ICC ADR and Arbitration Conference here in Africa. And it's a great moment because ICC Kenya has been in existence for a few years now, and it's only back in 2019 that the ICC Kenya received the status of National Committee for International Chamber of Commerce. And ever since that happened, with the International Court of Arbitration to which I belong, ICC Kenya has been actively working at doing capacity building, increasing knowledge and attention of the local community with respect to issues of international arbitration generally. So this conference is the way to bring all of that together, to bring the arbitration community locally and in the region here in Nairobi, and to discuss emerging trends of international arbitration in Africa. But I think what we mean by that, and more importantly, is what are those issues that are of importance for the local community, and how do we as a community build our profiles and build our practice of international arbitration here in the region.
For me, perhaps, what is the health status of arbitration or ADR in Africa? In terms of membership, in terms of perhaps even cases that are being arbitrated in the continent, from where you sit? So
from the perspective of the International Court of Arbitration, Africa is very present in our arbitration cases. So our institution is a dispute resolution institution that administers arbitrations happening between commercial parties or between government and commercial parties on a daily basis. So out of the over 1,800 ongoing cases that the ICC court oversees, there is currently close to 9% of those cases that are coming out of the African continent. And what is important to know is that that figure actually is a sharp increase from the past. So in 2020, that same figure of the number of African parties involved in ICC arbitrations was of roughly 7%. So we've seen about 13% increase in the number of parties from our continent involved in our cases. I think that is a testament to the fact that parties, commercial parties in Africa, are more and more involved in alternative dispute resolution, that they find in that dispute resolution method, and particularly at the ICC, what they need for their businesses to be able to continue doing business while disputes are being dealt with, and that we can see in the figures I'm talking about. I think that number is also a testament of the very important economic activity that is going on in the African continent. I mean, it's a continent where most countries are developing countries. We have a few emerging economies, and Kenya belongs to those. But generally, everything is still to be made. And because we're in that situation, we see two important things through the lens of ICC arbitration. One, public government parties are extremely present among African parties in ICC arbitrations. They represent currently about 50% of our African parties. And that is no surprise in a developing continent where the government is the first economic agent in most transactions, right? The second trend that we see is that there is a lot of outside the continent investment into Africa, and that is not a trend that we expect to go to slow down in a way. And that translates again in a high number of cases at the ICC court involving African parties that will have to do with investment intensive industries such as energy, construction, extraction of raw minerals, and we now see new industries coming up as well. So we heard today one of the panelists tell us about new technologies, and precisely we do see a pickup in the number of cases coming out of that particular area of the economy. So I think that's what I can say about how what's the positioning of Africa within ICC or with vice versa.
Two things for me that I want you to give as a comment. The first one is this trend on matters of integrity, corruption, or even rogue lawyers who still take advantage of the ADR process. What can you comment about that?
Well, issues of corruption have historically always been at the heart of the practice of international arbitration, and let me explain. Because arbitration, the practice of arbitration is relies on arbitrators who are not governmentally sworn judges, but are private judges, and whose regulation in terms of ethics relies on private ethics. The possibility for arbitrators to be corrupt has always been an issue of concern for the practice of arbitration. That said, we need to be clear that this is not a general issue that touches a vast majority of cases. This remains an exception, and it has to be clear that that's what we're talking about. Now, because it's an exception does not mean we should not tackle the point. And that's why I think the panel earlier today spoke very lengthy about the question of how do we regulate the profession to make sure, self-regulate to make sure that practitioners acting as arbitrators do not give in to this type of practices, or make sure that those who do are called out and that they're identified, and we make sure that they cannot keep perpetrating this type of extremely damaging actions in the community. And when I say damaging, of course, first and foremost for the parties at stake in the dispute, but more importantly for the whole community of international arbitration and local arbitration practitioners, because the perception of corruption will then impact us all, with parties moving away from that dispute resolution mechanism, which we should very heavily combat.
Good. The second one, and lastly for me, it has to do with the case flight to other jurisdictions. A case is generated, or emerges from an African country or even the continent, but eventually the adjudication has to be done in other jurisdictions. As far as ADR is still nascent and growing in Africa or in the continent, how is this affecting in terms of recruitment, in terms of growth of the sector from ICC's point of view?
So I think it's important again to look at historical perspectives here. As you said, arbitration and ADR is growing in Africa, right? So it's historically an area of practice of the law that was concentrated in the hands of practitioners in the West. There has been a lot of awareness made about that, and about the fact that as much as that can be okay when it comes to cases involving commercial parties in those jurisdictions where those arbitrators sit, it is problematic that you will have, let's say, 7% of ICC cases, 9% of ICC cases involving African parties, and a much lower number of arbitrators coming out of the ranks of African practitioners. So I think one first thing to say is that the arbitration community at large is now very largely aware and discussing that issue. There's currently a panel that is going on diversity during our important conference here today, and precisely the ICC has strived over the past 5 years at actively promoting more diversification of its own ranks, of the arbitrators that sit in its cases, and generally of the practitioners that it has in its cases, whether they are counsel, tribunal secretaries, experts, and so on and so forth. Now, the flight of cases from Africa that you're talking about is also a result of the at some point a lack of a critical mass in terms of resources on the continent. That is shifting. The work that my department, ICC Dispute Resolution for Africa, does in Africa is capacity building for lawyers, for clients of arbitration as well. You know, companies to raise awareness within the ranks of our clients that you can actually have your arbitration with a seat somewhere in Africa, if you're a Kenyan company in Nairobi, if you are a company in Uganda in Kampala, and so on and so forth, that you can also decide to pick arbitrators who have the requisite knowledge. And I insist, you need the arbitrators to have the requisite knowledge and in arbitration and happen to be from your jurisdiction, which is a win for you as a business, because that means that you will have somebody who understands the law applicable and who understands the rule of arbitration, right? That is essential. So ICC, by doing these trainings that we do, we've done one yesterday on the conduct of arbitral proceedings for our colleagues here in Kenya, contributes to changing the scene in a way and changing the state of things by saying we're going to build capacity. We have excellent lawyers here in Africa. We're going to bring them the knowledge of the procedure that arbitration and ADR is, and based on that, they're going to be able to retain those cases in Africa that are being dealt with elsewhere.
Very good. Finally, let's talk diversity and inclusion. The role of women or the impact of women in the ADR industry in Africa. From where you sit, what is their contribution and where is the future?
Well, from where I see, the role of women is the same as what the role of men is right now, or should be. The reality is different. That said, things are changing again, just like for African practitioners, things are changing very quickly for women. That is also the result of an intense work of introspection of the arbitration community, which over the past 10 years has faced the reality that its ranks were not diverse enough. And when I say diverse, it's not just gender diversity, it's also ethnic origin diversity. So on the basis of that observation, there has been a lot of initiatives to make sure that women arbitrators who have the requisite experience have equal opportunities to sit in arbitration cases, that they have equal opportunities to participate in this type of conferences, which are excellent platform for an arbitrator to make themselves known. And for example, ICC has a charter of conduct that, according to which no conference under ICC banner should have less women than men. A step just like that is extremely important to make sure that women have the place they should have in the practice of arbitration. And you can see today that the organization called Arbitral Women is a supporter of our conference, and the reason for that is that we meet the standards of female-male balance and equality. So all of these are extremely important issues. As I said, women has just as much as a space and should have as much as a space as men have in arbitration. And finally, talking more specifically about African women, one thing that I want to note, and when listening to our colleagues earlier, it came to me how striking it is that because Africa is coming later into the practice of arbitration, we have a chance to do things differently. You see, because we're growing as a continent in the practice of that legal area of arbitration and ADR, we have the opportunity to, as from the scratch, call those issues to the front and make sure that we don't fall into the mistakes that other jurisdictions have. And we see it already. There is a huge amount of women practitioners of arbitration coming out of African ranks who are senior, who are recognized, who are being appointed, who are vocal. I'm thinking of someone like a colleague in Nigeria, Funke Adekoya. I'm thinking of our ICC court member, Njeri Kariuki, here in Kenya. Our vice president, Ndanga Kamau, who is a young woman arbitrator, is also from Kenya, and is another example of these women who we're aspiring to see shine from Africa in the practice of arbitration. Okay.
Awesome. I have enough to work with. I'm grateful. Thanks for your time.
Oh, my pleasure.
Good. I think Kosawa, your content to the
Okay, good morning again, everybody.
It's a problem of sitting at the front, just like engagement.
Okay, I hope you all enjoyed your tea. Welcome back. Okay, so it's time for our second panel. So this panel is going to be moderated by Catherine Moulton. And just a quick introduction. So she's a solicitor, she's a fellow of the Chartered Institute of Arbitrators, and she's also the managing partner of Moulton and Partners LLP in Nairobi. So I'd just like to
On? Yeah. Good day, everybody, both virtual and in person. Thank you for coming. So in the past few years, there has been a visible and voiced focus on ensuring diversity in international arbitration. However, despite the volume and value of arbitrations coming out of Africa, there remains a very low percentage of African arbitrator instructions. I have heard the international industry at least be described as male, pale, and stale. So today we consider, does that remain the case, or, as I was delighted to hear Ms. Noella Lumbano state on Alim's panel, is the future female? We will tackle this wide-ranging topic and the need for change with my very esteemed, and please note also very diverse, panel of speakers, some in person and some zooming in. So we have with us today Ms. Jacqueline Oyuyu, who had planned to be here in person, but unfortunately because of the change in timings, she is now joining us remotely. I have Mr. James Ngotho here with me today, Ms. Madeline Keme from Tanzania, Ms. Dana McGrath from the US, Ms. Asunta Ndami also here with me, and Reshma Ugora from the UAE. We pray that the technology remains our friend throughout this discussion, and I will do my very best to keep things timely. I will not run through the bios for each esteemed panel member for that reason, but I'm told they will be made available during each speaker's discussion. So, I hope everyone is on the screen. I can't see anything from here. But first question is for Dana. Dana, can you hear me?
Thank you.
Yes, great. Dana, how do you see the fostering or the progression in terms of gender equality and diversity in ADR and arbitration?
Well, good morning from New York. Thank you for the invitation to speak at this panel and share ideas on how we can advance diversity. And I will be speaking about some of the organizations that I have been involved with that have been promoting diversity, some for 30 years, some for 10, some for just a few years. And the proliferation of diversity-focused organizations, I think, is really a testament to the arbitration community's commitment to diversity. So let's start on a sort of a high note. What are we doing and who is doing it on a global level? But then I also like to highlight that diversity in the end is a regional issue. And it is important that there are regional organizations that work together with global organizations to achieve diversity.
Apologies, David. Just sorry for 1 second. Her screen was available. I saw it there on the right, and her camera was on and her mic was working. If someone could assist, please. Apologies, Dana. We couldn't see you.
Oh, okay.
You've just gone past it again. Sorry. Oh, where has she gone now? There, blue back screen. Okay, sorry, Dana, thank you very much. We heard everything, we just couldn't see you.
Okay, conscious of time, let me tell you about a few organizations that have been promoting diversity, one of which is Arbitral Women, which was mentioned, I think, earlier in the conference. And Arbitral Women is a global organization that was founded in 1993, so almost 30 years ago, and it is focused on gender parity and has been working for decades on that issue. And as I mentioned earlier, that issue and diversity in general has gained tremendous momentum in the last 10 to 5 years. The way that Arbitral Women tries to advance diversity is, well, we have several programs, one of which I think is really helpful for everyone to take note of if you are considering being a member of Arbitral Women, and that is the news and member news about our members. Because one of the big obstacles to achieving diversity in international arbitration is introducing the international community to diverse members of the community as arbitrators, as lead counsel, or many other roles. And so these global organizations like Arbitral Women try to promote the visibility of diverse talent in our field. And if you can find the women, if you can find the diverse arbitrators, if you can find the diverse counsel, then you can instruct them or appoint them. And so how do we do that? At Arbitral Women, we promote our members through our members news page, and periodically there's also news alerts that are circulated by email that contain information about women who are members of Arbitral Women who have achieved a promotion or an appointment or have some other professional development. And together with announcing that professional development, Arbitral Women provides a short synopsis of their credentials, essentially a mini bio. And so if you go to the News About Members page, you will find fortuitously a mini bio of a broad, diverse section of the female community in international arbitration. So getting the news out to people about who in the community is qualified to serve in the various roles, I think is critical to give visibility to the women who are not being recognized and to other diverse members. There are many other programs that Arbitral Women offers, including a mentoring program and a parental mentoring program. And we put out newsletters in which we celebrate and memorialize events at which diverse members speak. But I think that in order to move the needle, it's really important for people to know who are the diverse members of the arbitration community who may have been inadvertently overlooked. And we do that through promoting them on social media. Moving on to the Equal Representation in Arbitration Pledge. This is also a global organization that is focused on promoting gender parity and diversity in international arbitration. And as many of you may have heard, the pledge really invites individuals and organizations to make a pledge to keep diversity front of mind and to take steps, concrete steps, to try to advance diversity. It's often asked, what are these steps? And in response to that question, the Equal Representation in Arbitration Pledge, which I will refer to as the Arbitration Pledge, has put out a series of guidelines that are basically bite-sized steps and techniques that you can use at your law firm or in-house if you're with your corporate counsel or in any other context to try to find diverse arbitrators or find diverse counsel. And those can all be found on the pledge website. They are no more than 2 pages and they're tailored to your specific needs. Finally, I would like to emphasize that the arbitration pledge has subcommittees, and the subcommittees are both geographic in focus and substantively in focus. So, for example, we have the ERA pledge has a corporate counsel subcommittee that drafted guidelines specifically aimed at assisting in-house counsel in finding diverse arbitrators and counsel. But importantly, there is an Africa subcommittee of the arbitration pledge, and that is focused on promoting women and diversity in Africa. One of the ways the pledge does this is by holding events that feature diverse talent. They also hold Meet the Arbitrator events around the world. Some of these are in person, many of these are virtual or hybrid. So to learn more about the Africa Subcommittee, I encourage you to visit the Arbitration Pledge website. Finally, given our time constraints, I'm going to move on quickly to another organization, and this is REAL, Racial Equality for Arbitration Lawyers. This organization was launched in the middle of the pandemic in January of 2021, and to my knowledge, it's the first global arbitration organization that is focused specifically on race. I'm fortunate to be a part of the steering committee of that organization, as well as the pledge and prior president of Arbitral Women. So I've been living this, I'm not just talking about it. And back to the Racial Equality for Arbitration Lawyers, REAL focuses on trying to increase access to the arbitration community for all who are around the world, excuse me, and importantly, to empower those who may find like socioeconomic or technical barriers that preclude them from participating in events like this without the assistance of technology. So I think that REAL and the Pledge and Arbitral Women, which, as mentioned previously, is a sponsor of this event, a non-financial media sponsor, we embrace the fact that this conference and many ICC conferences are hybrid to afford access to those who cannot travel to be at the site of the conference on that day, but wish to have the benefit of the knowledge sharing and dialogue that is taking place. REAL also has, in its first year, thanks to the generosity and support of many, many arbitral institutions, including the ICC, has awarded almost 70 scholarships to young practitioners around the world who are part of REAL to afford an opportunity for racially diverse members of our community to attend conferences and enter our community. I think one of the most difficult things for young lawyers who are starting in this area, as well as seasoned lawyers, is entering the space. How do you become part of the international arbitration community and recognized such that you can have a meaningful role in the community? And all the organizations that I have mentioned, I think, share a common goal in trying to increase access to the international arbitration community and increase awareness of those in the community of the diverse talent that we have among us. So I think that in the interest of time, I will yield the floor to my colleagues. And if there are any specific questions for me, I am happy to answer them. Thank you.
Thank you so much, Dana, and for making yourself available in what is presumably the very wee hours of the morning there, and for your very inspiring and passionate answer to that question. There's a lot to take away for both the more esteemed and the younger members of the community, as you say. Thank you very much. Okay, so from a slightly more up-and-coming perspective then, James, could you please discuss your views on equality and diversity in the profession? What that has been done is working. Oh, I'm off. And what is not working, or what more could be done? Thank you.
Thank you very much, Catherine. Thank you very much to those who've set this up and for everyone who's here today. This is a very important question, particularly to me, because where I come from, or rather not physically, but in terms of my progression in my own career, what I'll be saying will be, in a sense, more personal than I had anticipated in terms of what diversity when it comes to young practitioners is, and what needs to be done, what ought not to be done, and what I would think would be the best way to go about it. So with that out of the way, it's important to start by realizing what, perhaps for us it's recently fresh, what the first panel and in general our seniors have imparted on us. And before we move into special interest groups, before we move into pushing those minorities up to the front, you have to meet a basic criterion such that once you are being fronted, you will not be questioned on the basis of the minority group or the group that, so to speak, is pushing you forward, be it through the promotion of women in arbitration or the promotion of young practitioners in the same practice. You will not be questioned on your basic tenets of your profession. And so it's important to start by being good. I know that sounds a bit curt, but it is important not, as a matter of fact, more is expected of you if you are coming from a point of minority. And it may not be fair, but that is the case. And you will be expected to make fewer mistakes. You will be expected to be actually good at what you do. And while this is something that everyone expects out of every practitioner, it's not a conscious thought for those who are experienced. It is a conscious thought for those who will come in under this banner. And so you have to actively and consciously make sure that what you present is up to par. So I won't really dwell on that because in a sense that's stating the obvious, but I thought it would be important to set that as a base, because you need to set yourself up professionally. And as Professor Senior Counsel pointed out, as well as my senior Jerry, she pointed out that it's quality of service. That should be a priority even before you move to any form of specialization. Now, I'll move on very swiftly into now the special interest group, and in particular the one that I personally represent, which is the young members group. Now, it's important when we are talking about diversity to identify what agenda are you pushing and for which particular faction of people. And I'll speak particularly with respect to young people, and it's very generic when I say young people, because we have to create a cap. What exactly is young? Everyone here wants to feel as young as possible, and no one wants to be told that they're old, even if you are seasoned in what you do. So what I mean by young is in the profession. You might be young in the profession, but you might be seasoned in what you do generally in your life. So if you're young in the profession, then you will have, and there's no other way to say this, you will actually have a difficult time setting foot in, because this particular profession is experienced, or rather experience biased. Everyone would want to go for the gray-haired person because they have a presumption that this person has done quite a bit. They will not dig into what he or she has actually done. It's presumed. However, anyone else will have to question what you have done as a young practitioner. You will send your CV. If it's 1 page, 2 pages, it already is starting to create some anxiety. So what then to do as a young practitioner in order to meld into this particular space? How then can we maximize on diversity as a topic for young practitioners to ease? And I have 3 simple points, and I'll limit myself to 3 because we do not have all the time in the world. There are very many. So I'll mention what I perceive to be the most important. 1, we are experiencing one of those important things right now. We are all here. Visibility. No one will look for someone if no one knows you exist. It's as simple as that. And as much as that sounds like a basic tenet, younger people have to be more intentional and more intentional in making yourselves visible. Again, at the risk of sounding very obvious, this is a very important place to start. What is visibility? We all, as young practitioners, but this is a broad assumption I'm making, but now that we're in the digital age, as we all like to call it, we are online somewhere, and so is quite a number of institutions and very many other people who are interested in what you have to say. Now, that I think has already cut across. There's no need to hammer that in further than that. But the second, in my view, the second important thing as a young practitioner is to identify exactly what you're trying to seek in the profession. You are not coming in to reinvent the wheel, but as I mentioned initially, it is important to get the basics right. So as a young practitioner, you are joining a market that is getting more saturated by the day, by the minute, by the second. What are you bringing into this profession that someone or a body or an institution, a potential client, a potential colleague has never heard of? And even if they've never heard of it, maybe they have. What aspect of it are you hacking into? And it's important to have a place or a very particular intent when you're coming in as a young practitioner. And more so, and now I link this to the actual topic of discussion being diversity, is you will come in and you will be expected to offer what anyone else would offer, but what else on top of that, and what will set you apart? Because not only will you now be a beacon for the niche that you're representing, you will be a successful representation of what we are trying to do in order to make the arbitral, or rather the dispute resolution setting, more diverse. And it's important for other people to see that not only can you get in, you can get in and succeed. That second part is important, and very many people may forget about it, not just generally, but forget to mention it. It's important to succeed, to show that this is something that can work for you as someone who is underrepresented in this particular profession. Lastly, what I would consider very important as a young practitioner is, and this is going to be broad, but is to identify the opportunities that exist for you. Now, why I added for you is because opportunities are everywhere. And I'm sure you've overheard this, and it's been mentioned to everyone in this room at some point in time in their lives, because we've all been young. You need to identify, you need to be proactive and put yourself in a situation where these opportunities are being presented to you. And even if they're not, you need to actively look for them. That goes without saying. And what these opportunities are, there are a plethora of them, including one, we are experiencing an opportunity right now. All the faces that are in this room have something to offer, even if you've never met them. Meet them all. What is preventing you from going up and shaking every single hand in this room? Fine, COVID prevented us from doing that. We had the perfect excuse for a year or two. Now we need to come back to the table and make sure we get down to what exactly, in terms of the profession, the word would be networking, but it's more than that. Make yourself known, because it ties into the first aspect, which is visibility. And once that happens, the options are presented before you. And once options are presented before you, you as the person representing that particular niche, and even if it's someone who is not representing a particular niche that you're interacting with, they have something to impart. Most of the time it's a business card that fits in your pocket, but there's more. If you choose to go down that path, and for you to go down our path, you need to know what exactly it is and what exactly you're looking for. At the risk of sounding very generic, because these tenets are very important in my perspective, and I believe that in as much as I keep drawing back to me, it's for the benefit of those who find themselves in any position where they need to not only be in, but also succeed in. And I'll leave it at that. If any other questions, I'll be happy to answer. I'll give it back to the moderator. Thank you very much.
Thank you so much, James. As well as information in terms of us raising our profiles, an important point you made, I'll just address it again, was that we, as any form of minority, but especially the young, need to be providing a quality service. That's something to take away for everybody. Okay. The next panelist, Miss Madeline Keme, is she on the screen, please, before I start?
Yes, Catherine, I am on screen.
We can hear you. Just give us maybe 30 seconds to get your lovely face visible. There you are. Madeline, thanks for joining us today.
Thank you for having me.
No problem. Although we are neighbours, you will have your own perspectives, no doubt, from Tanzania. Please discuss for us any challenges you have faced as a woman in ADR during your career and how you overcame those challenges. Thank you.
Thank you, Catherine. And your question is very close to my heart. I echo that the future is female in arbitration from our previous speaker, Ms. Noella. I'm fully supportive of the fact that we have made great progress in improving our presence within the arbitration community, not only on the continent but globally. ADR is inclusive in theory, hence not only do we advocate for this future work, not only for women, the youth, we've heard from James, the youth, people with disability, the different racial backgrounds, as we've heard from the initiative tagged as real. I believe to a certain extent these commitments are the pivot or the start to the kind of leadership that we anticipate moving forward into the future, that sets the scene, allows for the doors to be open, walking the talk. I think this is where it needs to be stressed on, walking the talk and keeping the doors ajar for those minority groups to keep looking towards this kind this playground, this dispute resolution arena that we would like to maintain with its level of high quality arbitrators, the kind of work that we anticipate the arbitrators will deliver. We heard from the first panel about having rogue arbitrators. This is not the ambition we seek for. We seek to have the community that lives up to the expectations of the arbitral community in itself. Undoubtedly, and before I get to your question, a great example is the ICC. It has done, as we heard earlier from Diamana, tremendous efforts collectively with its partners, the members of the court, the stakeholders I've seen and been part of in creating and progressing this particular topic within the continent. And we see that with the presence of a dedicated unit headed by Diamana. So representation on the of African states or members, such as Tanzania, came into the court sometime in 2018. So we've seen an increase in that. I remember receiving that email, and really it was an exciting opportunity for a young African, Tanzanian-based arbitration practitioner. Appointment of women in arbitrations that are administered by ICC. This has been and is continuously being marked as and progressing in huge numbers. And so the reality is really a positive and wants to be reckoned with. So getting on now to the remarks on visibility that James has touched on. My story is really coming back from the same advice that we're getting from the YMG president. Breaking the norm of that breaking the norm was what I had to do. I as an arbitration practitioner in Tanzania made continuous efforts, continue to date to reinvent and be awakened, or at least be of a position to understand the challenges that are facing my community, and that allows me to evolve with my community and maintain the visibility and the presence that one needs to maintain in order to gain this to stand at par or close to the par that we want to achieve with our counterparts. So in 2012, when I started my career, the challenge was exactly that I was young. I was coming from in-house as an in-house counsel and not from private practice. And so I did not fit into that closed-knit group that we call the Club of Arbitrators. In most jurisdictions, we tend to have realized that there was a closed group of persons that arbitrations were being handled by, and that consisted mostly of retired judges. And so therefore breaking that hardwood door meant that I had to create and predefine myself prior to getting onto that roadmap that I had set out for myself. And so having to set yourself a plan of action is one of those ways that I overcame that challenge. I had to recreate my practice and strategy entirely from that crowded gate that I saw, the entry gate that I saw. So developing my own style and presence and having a plan of action was the key to the success. I started off by developing my skills, as we've heard, the skills, the expertise, mastering and understanding the art of arbitration and the dynamics of that procedure. I literally had to bring my own seat into the room. And that was by being innovative at that time, I would say, by putting myself in the room, offering transcription services or arbitral secretary services, or even as a private consultant to tribunals or councils. Remember, I was young, I was a woman, and the experience bias really did hit me hard. And so therefore, that recreational approach did give me a little bit of a way towards the realities that I'm now witnessing. So understanding also that while biases do exist, they do not always based on the gender of that person. They also based on the individual's qualifications and expertise. And so ensuring that, you putting myself or putting oneself onto these visibility networks that we have, and ensuring that your individual qualifications are known and they stand out. That was a critical advice that I would give to the participants today. Targeting a market. Targeting a market was also very important in the growth. Why I say this is that in Tanzania in 2010, arbitration was second to nil. It was being underutilized. The use and application of it was not recognized in terms of the legal fraternity not utilizing this mechanism. And so I somehow had to then say, okay, this is the situation in Tanzania. Where else can I gain experience? And that's when I looked out into the international arena. And over time, the community does define one's strengths and weaknesses. So let's not continue on the same pace. The advice that I usually give is that you have to reassess yourself, receive the feedback that you get. Not everyone is able to give you the feedback, but if you do get the feedback, use that feedback to enhance and improve on your presence, keeping yourself relevant and valid professionally. And I think another thought that I would, if I still have time, would like to share is that there has been a change of perception. There has been more confidence in the local arbitrators in the country. And so therefore you tend in the local arbitrators' performance in the country. And so therefore that also gives a positive sharing of the experiences in arbitration in Tanzania. And I think also this applies globally, as we've heard the great examples. We have heard the great examples of the top names, such as Ndaga Kamau, Funke Dekoya, we have Jerika Eruki. All these names are keeping are at the top and sharing their experiences and inspiring the young leadership that is to come. So I'm happy that over the past years, the gender gap I've seen in my capacity as Tanzania Institute of Arbitrators president, I've seen that gap closing in with more female arbitrators showing interest in the arbitration practice. The pool of women of arbitrators, of course, now I can say it's positively marked in Tanzania because we now have an accreditation system that was introduced in early 2021. And that accreditation system maintains a database. And if we look at the database, from the first accredited women arbitrators in the country, we had 89, a pool of 89 applications, and out of those 89, 13 were women. And then later on, or earlier this year in June, we had applications of 37 women, of 37 applicants, out of which 14 were women. And so that really, for me, is that we do have a good pool to build on and work on in terms of building capacity, building further awareness, and ensuring that arbitration as a mechanism is fully utilized and we grow together on that spectrum. And on my last note, maybe just to note the kind of leadership that we have in Tanzania that has really included the minority groups. For example, the Tanzania Institute of Arbitrators, the current president being myself, and the current composition of the council being equally male and female, 8 members, 4-4. And so that is, for me, a notable improvement, which we continue to build on together. And on that note, I think I will end my address there, thinking of time, Catherine.
Thank you so much, Madeline. I really appreciated your views on visibility and breaking the norm. You mentioned how you overcame the challenges of falling outside of the closed club. I think you referred to it as And despite the difficulties you've experienced, you ended on a very positive outlook for the future. That was great. Thank you so much. So next, we move on. Our next question is to Reshma Ugara. If we could please get her on the screen. Thank you. She's joining us from the UAE today. I can see her. Perfect. Reshma, good day.
Hello, hi.
I don't know
Can
what
you hear
time it
me?
is. Yes, I don't know what time it is with you, but thank you for joining us. I've got a question for you. You're a diverse African practitioner practicing internationally, and perhaps you would share for us today some useful tips you've picked up along the way on how to access support and navigate any challenges in developing our careers or expanding our practice, both on the continent and internationally. Thank you.
Thank you very much, Catherine, and hello, everyone. Thank you very much for having me on this panel. I'm very sorry that I couldn't be in Nairobi in person today, but I'm really, really glad that I'm able to connect with you all virtually. I hope that you have better weather than me because it's very cold and rainy where I am. Well, in terms of the question, we've heard from Dana, James, and Madeleine about the various initiatives that have been developed by the arbitration community, by institutions, and generally practitioners and people who really care about bringing more diversity to arbitration. And my part is to share what I did and how I, as a young African arbitration practitioner, access the opportunities to develop my skills and my personal experience in building a career in international arbitration. And for me, it really boils down to three main things. Firstly, developing a mindset and belief systems, a belief system that serves me and my ambitions, persistence, and then seeking support when I needed it. Having said that, though, I think we need to understand that we're all different and we carve our own unique path in our careers, but we can all learn from each other's experiences, and I certainly have. Well, regarding the first one, developing a mindset or belief system that serves your ambition, to put things in context a little bit, as you all know by now, I am from Mauritius and I am based in the Middle East. I'm also the first generation in my family to have gone to university and become a lawyer, and I come from a low-income background with no resources or connections in the professions. So although I had the ambition to become a lawyer and later an arbitration practitioner, I had no idea how I was going to achieve that. But despite my situation and the moments of self-doubt and imposter syndrome, like we call it, I had a core belief that I could achieve anything I put my mind to. And then it feels like the resources and the opportunities to achieve that started presenting themselves in my life. So just to share an example with you, when I was in university, I was selected to represent Mauritius in an international arbitration moot competition in India. I wanted to go, but we didn't have the means to pay for the air ticket. And my mom shared that with a friend in the community. And somehow this got to the mayor of the town that I used to live in. And the next thing I know is somebody gave me his number and told me to call him. And when I called him, he asked me, okay, what's going on, et cetera, et cetera. And I said, well, I've been selected to go on this mood, but I cannot because, we cannot afford it. And he said, well, okay, well, how much do you need? And he said, okay, come and collect a check the next day. And it's very interesting when those things happen. And I feel that there were a lot of other situations like that, and not just financially, but also in terms of support that came through. It's like I focus on what it is that I want, and the how somehow happens down the line. Because we develop a positive mindset and have those positive beliefs. And the second thing that really worked for me is that I have been very persistent and I did not give up. despite my circumstances. We all have different circumstances and take different paths to getting to where we want to be in our career. And it's not linear because we don't just want a career, we want other things too. So for example, we want to have a family, we want to live in a certain place, we want to support our community, etc., etc. And in my case, my husband wanted to pursue an opportunity to work in Saudi Arabia just when I qualified as a lawyer and was called to the bar. And I had the option to pursue my career either in London or go back to Mauritius, where I think my chances would have been probably better. But in the same way that my husband had supported my career, I wanted to support his career and I wanted to be around him. So I decided to go to Saudi Arabia, despite all the warnings that colleagues gave me that, my career would be doomed, there would be nothing that I could do, etc. And it's true that when I got there, it wasn't possible for me to find an opportunity to work there immediately. So I was a little bit creative about it. I reached out to my colleagues in London, in Mauritius, and I offered to work with them remotely by doing research and drafting work for their cases. And at the same time, I applied to law firms and legal practices in Saudi Arabia. I wrote dozens of emails, made lots of phone calls, kept knocking doors until finally one law firm gave me an opportunity to do a secondment. And slowly I built my experience through roles like that. And initially I did not do exclusively arbitration work, but I had the opportunity to work on international matters involving African cases, large oil companies like Saudi Aramco, Chevron. And because I had that international background, I was being sent the international clients to serve. It was a very challenging environment because I was the only woman lawyer at my firm and there were restrictions. So for example, at the time there was segregation and I wasn't able to meet with my male colleagues. But I think I was so happy that I had that opportunity that I somehow made it through those challenges. So eventually, from that role, I secured other positions in other countries in the Middle East. And I worked very, very hard in those roles to make sure that I deliver my best work. And this goes to what James was saying earlier. And eventually, colleagues and clients started asking to work for me specifically. And I think what's very important also when we are in jurisdictions which are not the main hubs or jurisdictions which focus on arbitration, it's very important for us to mingle with others in the profession and develop your connections. Because one of the things I kept thinking was, well, if I don't go anywhere, people won't know I exist. And that's why it's very important for us to connect and attend these circumstances. And it is true that when we come from an unusual background, it takes time for people to warm up to who we are and understand our capabilities, but they eventually get there because at the end of the day, what matters is the value that we bring to the work and to the clients and anything else that we're doing. The third tip that I wanted to share is to seek support when you need it. So like I mentioned earlier, I had no connections when I joined the profession, and I developed them progressively and along the way. And I initially reached out to people who are already established in arbitration, and they guided me and mentored me, and I'm so grateful to them. I do want to add that there may be people who will not respond, and that does not matter because the few people that do respond is enough. I think it's very important that we learn to develop with the skill of rejection and, the fear and anxiety that comes with putting ourselves outside of our comfort zone in order to succeed. And I know that from personal experience, it's not that simple, and we may have to have a different focused conversation about how to overcome those specifically. But in terms of arbitral appointments, I started to look for my first appointment about 5 years ago. And the way I I did it, I mean, I tried to trace it back. I think I reached out to other arbitrators and asked them how they got their first appointment. And I also made it a point to share with them that I'm looking for my first appointment. And I actually got my first appointment through a recommendation by an arbitrator who had seen my work as counsel. And so basically, he gave a recommendation to an institution that appointed me in the UAE. And I actually got a couple more appointments after that. Ex-colleagues have also recommended me for tribunal secretary appointments, which I took and from which I've learned a lot. I think it's a very good way to build your skills and to have insights into arbitration from the point of view of the tribunal. Now, yes, so I do feel that it's been challenging to build a career in the Middle East, and it was probably more challenging than others. But I also feel that it was more adventurous and quite enjoyable. And I do trace it back to having a growth mindset and a set of beliefs that served me, being persistent in finding opportunities to demonstrate my capabilities and asking for support when I needed it. And I'm very much a work in progress, but if I can do it, I think anyone can do it too.
Thank you so much. Great hearing from you, how you accessed opportunities to hone your own skills. And importantly, your unique and personal journey is very inspiring for us. I'm sure everyone would agree. The different aspects of support you received was great to hear, but also how you yourself made it happen. Thank you, Reshma. So, question 5 then is for Jackie. I saw your face, but Jackie, I think your camera is turned off. I hope you're still available. We are a little bit over time.
Yes, Catherine.
Great. Good day, Jackie.
On my end, my camera is on.
Yes, we can see you. Thank you very much. Jackie, you don't really need much of an introduction here. You have significant experience as a practitioner, being notably Kenya's 3rd female chartered arbitrator. But I would be keen to hear from you today about your service as a director. Markedly, you sit as the chairperson for the Nairobi Centre for International Arbitration. So first, what is the NCIA doing to safeguard professional, cultural, and gender diversity? And then secondly, if you don't mind dealing with both at once, please also take a broader view on equality and diversity from the Institute's perspective in relation to the challenges of positioning an African institution as a preferred arbitral or ADR seat. Thank you, Jackie.
Thank you, Shukran, Catherine, and pleasure to be with you all this now afternoon. Perhaps to enable me answer your question, Catherine, let me first speak to who the NCIA is and what the NCIA aspires to. The NCIA is established as a center for the promotion of international commercial arbitration and other forms of dispute resolution. We also have a wider mandate, perhaps as a prelude to discharging that first mandate, to promoting the advancement of alternative dispute resolution mechanisms, both domestically and internationally. So of necessity, then, we are required to engage with various stakeholders. And indeed, if you look at the composition of our board, we are drawn from different stakeholder entities, if I may speak to them as that. So I'm pleased to see our immediate former chair is here present with us. I see several of our directors also serving as either panelists or participants in this conference. And really that just serves to show that we are not drawn in a vacuum. We really are drawn from practice. Having said that, and speaking more then to the specific questions that you have asked, NCIA offers a neutral venue, firstly, for the conduct of disputes, whether they're domestic or international. And for that reason, then we have to maintain a panel of dispute resolvers. Currently, we have 4 panels, so domestic arbitration, domestic mediation, international arbitration, and international mediation. And our role, therefore, is not to determine these disputes, but then to enable users connect with dispute resolvers, and then, of course, on the tail end, then to administer the disputes from an institutional perspective, providing the support that I think Dr. Mutuba was referring to in the first panel, providing the institutional support in terms of the administration of disputes. And then as perhaps a parallel construct within our statute, we then have the arbitral court, which is expected to serve a neutral role in addressing any concerns that parties may have around, excuse me, the conduct of our third-party resolvers. So having said that, you can then begin to see that diversity for us is not just a question of who's sitting at the table, perhaps from a board perspective, but who's sitting at the table in terms of our dispute resolvers, who is sitting at the table in terms of our stakeholders. It has to be a very wide conversation around stakeholder engagement. And then, of course, who is sitting at the table in terms of our trainees, because we also have a component of training. And very recently, this was brought home very clearly for us because we had a participant, a potential trainee who wanted to participate in our trainings and ask the question around how user-friendly our trainings are from a person's living with disabilities perspective. So you then begin to see that for us, diversity is not just a question around gender or a question around experience. It's also a question around accessibility from a perspective of people who perhaps don't have the traditional capacity from a physical point of view. So having said that, then, we are constantly called upon to have conversations with a variety of stakeholders. Indeed, we had to have such engagement when we were drafting a national policy on ADR, which speaks to several of the issues that have been raised today, including the conduct of third-party resolvers of access to justice.
Apologies, Jackie, we lost you. Could you just repeat that last part? I think it was a technical issue. Thank you.
Okay, I'm not sure what the last part was.
Probably 1 sentence maximum. It just went a bit glitchy for me.
Okay, so perhaps the draft national policy is what I was speaking about before there was the disruption. And I was saying that it is rooted in 2 very broad principles. Firstly, the principle of access to justice, and secondly, the principle of diversity. So if we are supposed to speak about access to justice, who are these people that we are trying to enable have access to justice? If we're speaking to diversity, who are these people that we're saying must be represented? And I think each and every one of us has to ask ourselves the question of anytime you find yourself in a room and everybody either looks, thinks, or speaks like you, then you have to ask yourself the question of whose voice is missing, whose face is missing, and how do we then open the door, either from your perspective as a minority or from your perspective as a member of the majority, whose voices do we need to include in our conversations? And unfortunately, for many of us when we were starting out, the voices, as has already been said, were male, pale, and stale. But that has certainly changed over time, and we can credit, obviously, a lot of, let me call it, both overt and covert affirmative action to make sure that the voices then become more distinct and more diverse in terms of the messaging that we're receiving. And maybe in due course, Catherine, we won't necessarily have to have a specific panel on equality and diversity. We will hear these voices sort of weaving through the thread of every single panel that we're mounting in our conferences, so that we don't then have to have a specific panel that's dedicated to equality and diversity. Then that's not to diminish the place then of that conversation. It is really just to integrate it into every single conversation that we're having as dispute resolvers and dispute practitioners. In terms of the policy, the national policy that I alluded to, in addition to access to justice, then we are also hinged on the whole question around ease of doing business. And when we talk about ease of doing business, it's not just about sort of from a large corporate perspective, but for us, it's also the micro and small and medium enterprises. It's also the individuals who are engaging in any sort of commercial enterprise. How are they being enabled to resolve any disputes that arise in the context of the contracts that they enter into, or indeed the relationships that they enter into. Obviously, related to that are also the large infrastructure projects that perhaps our governments are entering into, bilateral investment treaties, very broad conversations then around who we must be engaging with as a center. Our job, therefore, is to provide institutional support to all these conversations, indeed sometimes to convene the players around these conversations, and to make sure then that we're not just having insular conversations, we're having conversations with every touch point, if you will, of stakeholders that we must of necessity engage with. So, as you said, very broad perspective on equality and diversity from an institutional perspective. Speaking specifically to your second question around the challenges of positioning an African institution, this perhaps speaks to a lot of what has already been said by many of our panelists this morning around perceptions, whether they're real or imagined. Is it true to say that because you are dealing with practitioners from a certain region, then you must of necessity expect behavior of a certain manner? Do we have certain presuppositions around the capacity of practitioners, and are those presuppositions then justified? If indeed they're justified, what then can we do to capacitate our practitioners to make them more visible? And visibility beyond just sort of the networking that has already been mentioned, but there are opportunities then to become more visible, even in terms of the journal, for example, that we publish. Who are the contributors to this journal? We will call for entries, for example, on a regular basis, and we try as much as possible to make sure that then different voices are represented in those publications. Other perceptions, perhaps around the capacity as an institution in terms of our infrastructural support, whether it's IT, connectivity, auxiliary services such as translation, transcription, competence in major world languages, and indeed that includes Swahili. So what is our competence as an institution in terms of those capacities? Is there integrity in our processes? Is there integrity in our dispute resolvers? If there isn't, how are we managing the perceptions, or indeed the actual instances of lack of integrity? At a wider level then, because we are an African institution, what is the perception of our judiciary? And this speaks to the question then of the enforcement of awards, where Nairobi is the seat. Is there perception around the capacity of our judiciary then to effectively enforce awards? Are there any questions around experience in terms of enforcement of awards? Are there any questions around independence of our judiciary? And what is the overall judicial posture towards arbitration? So from an institutional perspective, questions of perception, questions of our legal framework, questions of judicial attitudes towards the judiciary, and then of course structural questions. And all these, on the flip side, sound like challenges, but for us provide an opportunity then to engage, to capacitate, to build upon what is already existing, to enhance what has already been established, all towards that proper positioning of Kenya, Nairobi as a preferred seat.
Thank you so much, Jackie. I'm so sorry to interject. I'm being told that we're running over on time.
Okay.
Is there
let me close with this, Catherine.
Yes, thank you, Jackie.
Let us ask ourselves the question: are we going to change the world by example or opinion?
So much, Jackie. That was super informative and very insightful. I'm sure you've got another 20 minutes at least that you could share with us. But unfortunately for today, I have one final question for Assumpta. Thank you firstly for being here with us. So the question is there any individual input an arbitrator can make towards increasing diversity and equality in the profession? And is there a way we can use our unique arbitrator toolkit to break the bias or change the lens? Thank you.
Thank you so much, Catherine, and to my fellow panelists. I've been given the hard job to crown it. As you've seen, we've kind of taken a trajectory where everyone has chimed in. But I would chime in and say I sit here as a beneficiary. So my fellow panelists have discussed what institutions have done for them, what they have done in their individual capacity. But I'm here to tell everyone in the room, let's consider our unique selling points. As individuals, I strongly believe you have a unique toolkit. So what's in your toolkit as an arbitrator? Is it where you studied? Is it who you know? Because we constantly hear that our network is our net worth. But I would ask myself is, we constantly look at diversity and equality and inclusion as let them do and I will benefit. But what are you doing as an arbitrator? Are you actively engaged in sensitizing and creating awareness of every client who walks through your door? So constantly we look at ourselves as arbitrators or mediators. In fact, I'm sure if I asked each of us to describe ourselves, we would say, I'm an advocate of the High Court and an arbitrator and a mediator. All these things fall within your toolkit, but how you choose to look at it impacts how opportunities will come to you or not. So to answer your question, Catherine, yes, I do believe that we need to change and break the biases within ourselves first before accepting that other people are breaking them for us. So whether or not we say it in this room, we each individually have a bias to ourselves as practitioners. If you are under 35, young, or should I say up and coming, because young has really been redefined today by James. But if you're up and coming, the constant question you have in your mind is, I can't do this. This case is too big. But is it really? You sat in the same classes as your colleagues, so no, it's not too big. It's only too big in your mind. So breaking the bias starts with us. It starts with you as a practitioner. In your mind, seated in your chambers, break the bias in your mind first. After that, literally, the moon is the limit. And I say that because I sit here as a beneficiary. No experience is wasted. So when I think back about my first experience in arbitration, it literally starts when I was doing my undergraduate, where I was exposed to an arbitration course and I thought, you know what, this is it. This is what I want to do. Getting into pupillage, I know many of us seated in this room, you think pupillage is almost like a prison cell. Once you're locked in for life, right? So they say it. I can see several people across the room who agree with that. But I refused, I broke that bias and said, you know what, I will take my experience and I will run with it. Equally, choosing to do my LLM where I did my LLM impacted me greatly. And I thank you to Queen Mary, for those of us who are alumni in the room. You know you learn and get the best at Queen Mary. But that gave me an opportunity to sit and meet to the likes of Diamana. Not as counsel, but just a trainee. So no experience is wasted. Broke that bias in my mind, ran with it, and I remember telling Diamana and then Counsel Tunde, you'll see me soon, so get used to my face. Met my senior, Madam Jerry, and she inspired me, so I equally stand on the shoulders of individuals like these. And when I came back home after experiencing the UK and France for myself, I decided to come home and give back because I constantly believe it's about breaking the bias in your mind. So I take it upon myself for every client I meet, I need to educate. We need to educate. There's a presumption that because you've been given a brief, they actually know what arbitration is. And constantly, we know we will meet with counsel who tell us, can we mediate? Yet they mean arbitrate. Can we arbitrate? And then they mean mediate. So there is a lot of sensitization that we need to take part in. So it's really not an institutional thing. It is a me and you thing as an arbitrator.
as my co-panelists have said, carry the chair, bring the table, break the barriers, but let it start in your mind. If you can do it in your mind, you can do it in practice. And that's how I'll choose to crown it.
Thank you so much. So many great points, but an important one about pupillage and particularly mentorship. I'm currently benefiting from great support from much more esteemed colleagues in the room. Jacqueline, thank you. And I'm sure that's one of the better ways of us as young practitioners, or less seasoned, maybe James would say, practitioners coming through and receiving that support and knowledge. So I'm told we have definitely no more time. But let's all of us keep the conversation going, as there remains a lot of work to be done in respect of both gender parity and equality and diversity in the industry. Thank you, and a round of applause, please, again for the panelists. Thank you.
Thank you very much, Catherine. Okay, so after that very, I think, passionate panel, I would like to, there's going to be a slight change in our program. I would like to call up Dr. Peter Kwanjera, who is the Dean of Strathmore Law School, who's going to give us a presentation or a talk on the evolution of legal education in view of ADR. So welcome.
Good afternoon. It's my pleasure to be here, and I thank Alim Visram, the chair, for inviting me to share something very brief with you. I promise not to take more than 15 minutes. I had a presentation, but I asked them to set it aside. It's better to just talk. And really what I wanted to reflect on in those 15 minutes, and I'm happy I had one of the panelists just now say we need to educate not just lawyers and other professionals, but we even need to educate our clients on mediation, on arbitration. And so what I want to talk about really is what law schools should be doing in this regard. So of course, I think we all admit that our system is adversarial in nature. We've been taught law with regard mainly to litigation, whereby, you know, we go fight it out in court. It's a binary relationship, me versus you. But we do know that ADR then offers something that creates more peace and longer lasting relations than litigation. And when we think of law schools in Kenya, in Eastern Africa, we have, and those of us who are lawyers here most likely will agree, we have mainly trained law graduates on litigation, whether in the university or at the bar school. When you look at the courses that we offer, they are basically preparing you for litigation. However, the market is changing, and we have to think of what we call market-driven legal education. And that change in the market is evidenced by things such as LSK has 20,000 members. if you look at the year 2020, for example, only 60% of those took out a practicing certificate, about 11,800. The rest, about 39%, didn't take out a practicing certificate, and that has brought a question to our minds. What are the others doing? And why I'm bringing that up is because if you do an empirical study, you will then find that there are many people who, even after doing law, then proceed to do other things that don't involve going to court. And that number is growing by the day. And in Strathmore Law School, we will soon be doing a graduate tracer study, but the hunch I have anecdotally is that there are quite a number of students who graduated, say, from Strathmore Law School who are not in litigation, who are not in contentious dispute resolution, and who are looking for more pacific methods of resolving disputes. So that being the case then, is a challenge upon law schools to react to the market. We cannot continue churning out lawyers who are basically binary minded. You know, it's defendant versus plaintiff, and so on, so versus this and this. So we need to move from that mode of educating people. It means that legal education then has to be disruptive. That attempt has been made. There was a Moigai report earlier on. I was hoping I'll see the former AG here, and he did an intense research and study on legal education in Kenya. And one of the recommendations that he made is that ADR should be made a compulsory course in the undergraduate and in the bar school. But that particular recommendation was not adopted. So we continue having it as an optional course, and law schools decide whether to offer it or not, and yet we can clearly see that the market is moving. When you think of our corporate entities, what are they doing today? They are investing heavily in in-house legal departments. For what purpose? To comply with law, to avoid litigation, because we know that with sharp litigation comes reputation risks, comes a lot of resources being tied down, and you will see that more and more corporate entities are having in-house counsel departments, people who don't go to court, people whose work is to ensure that we minimize going to court. I happen to be the first legal director of Strathmore University, and when I was appointed, I filed quite a number of disputes in court, and the first thing we did was to negotiate, arbitrate, and mediate many of those, so that then we ended up with very few disputes in court. And that gives you peace of mind. You're able to move on with your business. And so law schools then have to reciprocate this demand from the market by doing this. So of course it is not enough to say we have taught ADR as a subject. In Strathmore Law School, we do teach ADR as a unit compulsory to the third-year students. And then when we reviewed our curriculum in 2018, I think it was, we introduced international commercial arbitration, which Mr. Alim Visram has been teaching. And I must say, to his credit, being an elective course is one of the most famous electives, actually the most famous, because normally electives have a minimum of 30 students and a maximum of 75. But guess what, with international commercial arbitration, we are at 100 for the last 3 years. Meaning that there is real interest in the young people to get skilled in this new wave of solving disputes. Then, of course, there are other, I would say, supporting training things you have to do. And one of the things we are doing now is to get involved in arbitration moot courts. I think now we have 3 moot courts. One is by CIARB. The other one is by the National Center for International Arbitration, and we are also now getting into what we call the William Viss International Arbitration Moot. Strathmore has participated. We do have an NGO from the US called Africa in the Moot that discovered 5 years ago that there are no African law schools in this moot court. Yes, it's one of the biggest moot courts on arbitration. And Africa in the Moot headed by Stephen Fletcher and supported by Justice Anne Claire Williams from Chicago, has really been training our students to prepare them for that moot. And I think last year they trained 13 law schools from Kenya, Rwanda, Uganda, basically the East African countries. And the fruits are very clear. I think last year Strathmore was able to make it to the round of 16 in the international. We have not won it yet, but it's a way of continuing to put that skill out there, and so that when the graduates come out of law school, they have in them not an idea of arbitration, of mediation. No, we don't want to have an idea. We want them to have a culture. We want them to have it as something that we will try first before we go into this thing of going to court and spending years and years disputing in court. Of course, to support that, of course, people have to realize that law is one more way of dealing with disputes. There are other disciplines that you have to show up. And for example, in Strathmore, we offer a peculiar subject called economics for lawyers, because we think a reason why disputes stay in court for too long is because sometimes lawyers, especially the ones hell-bent on litigation, do not appreciate the economic impact of having a dispute in court. So in Strathmore Law School, we have a compulsory unit called economics for lawyers. And then later on, there's an elective subject called economic analysis of law. And what they are taught in those two units is basically to analyze the economic impact of having a dispute. What does that mean? What resources are tied down? What is the actual cost of doing this? Because sometimes the actual cost is seen as the legal fees I'll charge. There is something beyond that, and it is bigger than the legal fees. Then maybe to conclude, I will also say that we have done something, which is to sign an MOU with CIARB, in which they will be offering the course on arbitration to law students in third year, so that by the time they graduate, if they score, I think, more than 55% in that initial exam, they can already apply to join the institute. Yeah. So that way, you start creating that culture warily. And it is our hope, for example, through the Africa in the Moot, because there are more and more law schools in Kenya that are getting involved in the arbitration moot, that as deans of law schools, and we do have a group. We don't have an association, we have a WhatsApp group, and from time to time we meet, and we are challenging each other, both public and private law schools. Can you be more innovative in your curriculum? Because the Council of Legal Education and the CUE definitely have left us with a leeway to be innovative and to include some of these courses in our curriculums to ensure that we create that culture. So, and I'm happy that the industry, quite a number of law firms, and I also say CIARB, and now I'm sure we'll be working with the LIM, with ICC, have really supported this innovative way of doing legal education. So I will say thank you for your support and continue supporting. We will, I can see familiar faces here, and we will continue looking up to you and looking out for your support for our law students as they do this. And it is my hope that law firms and people who actually do arbitration will continue taking interns, and as they take those interns, because we do require law students from Strathmore to do a mandatory internship in a law firm, in an in-house counsel department. It is our hope that when they go there, when we go to supervise them, they will also tell us, in this particular law firm or in this particular legal department, we have actually handled some form of ADR. When we go for that supervision of our students who are doing internships, unfortunately, most of the time the students will tell you, oh, we went to the Employment and Labor Court, or we did this conveyancing. So if you ask them what they learned, you will not find a student saying that in this law firm, you know, we handled an arbitration, we handled a mediation, now I know what this is all about. So it is in that sense that legal education has to be disruptive, and law firms, of course, have that role to play, because once the students leave our law school, they will come to do pupillage. Although, as I said, for Strathmore, we require, even before that, at the end of third year, they do a legal practice attachment in a law firm or a department an in-house counsel department of a company. So it is my hope that we will continue pushing to create that culture in our students. We also have a dream, and this is my last point. I have heard people say we have done a master's here. We are hoping with CR to collaborate on developing a master's in ADR. We already signed the MOU, so the next step now is to work on it, and that way we will be putting out more skill and more expertise into the market at that level. So I thank you for paying attention. I promise not to be between you and your lunch, so I hope I have kept the promise. Thank you so much.
Thank you so much. And thank you for sticking to your promised 10, 15 minutes. You're looking at me very expectantly, and I would like to suggest that we have one more panel and then break for lunch at 1:45, going to 2, so we can at least try and catch up with the program. So with that, I would like to invite Nikhil and his panel. Sorry, I've forgotten who's on your panel, Nikhil. So yeah, Nikhil, Mr. Ngodo, Engineer Howard, Martin. Okay, so as they come up, I can just briefly introduce Nikhil. So Nikhil is a director at J. Miles & Co., and he is also our vice chairperson at the ICC Kenya Commission on Arbitration and ADR. And today their panel will be discussing disputes in real estate, infrastructure, and construction. So thank you. Over to you, Nikhil.
Thank you very much for the introduction. We promise to keep this short. I know everyone is very hungry. So just to start off, I think this is a very important topic in ADR. We've seen an increase of investment in the region. We've seen a number of infrastructure projects, and largely the mode of dispute resolution is ADR. And a lot of you may be familiar with FIDIC contracts, which govern most construction and infrastructure projects. They actually have, in most cases, ICC as the end form of dispute resolution. So the topic is not very common in international arbitration conferences in the region, but for 2 years, the ICC Kenya has thought it's very relevant to include it as a topic. I won't go through everyone's profile. They're very distinguished panel members. I'll just introduce the members very briefly. Is Chloe on the screen from Johannesburg?
I'm here and I can see you. I don't know if you can see me.
We can't see you yet, but let me start by introducing Chloe de Jager. She's a senior associate at the law firm of Pinson and Masons at the Johannesburg office. Chloe specializes in construction law with a focus on dispute resolution. She is listed as a Who's Who legal arbitration future leader, among a number of other accolades which are all online on her profile. Welcome, Chloe, from South Africa. Moving on to Martin Bugwa, who's at my far left. Martin is a construction project manager and an ADR practitioner in the field. He was involved in, among a number of other projects, the Government of Kenya Affordable Housing Project. To my immediate left, we have Paul Gotho, who does not need much of an introduction, but I shall anyway. Paul is a full-time arbitration practitioner. He is on numerous arbitration institutional panels, among other in Africa, China, United Kingdom, and the United States. And to my right is our infrastructure expert. Howard is a civil engineer with over 16 years experience in design and construction of infrastructure projects spanning a number of sectors. So with that short introduction, welcome panelists. Can I just start with Chloe? Chloe, can you hear us properly?
Yes, I can hear you loud and clear.
Great. So just starting off on the construction element of dispute resolution, what are the typical types of contracts that are being utilized for major real estate infrastructure and construction projects? And in addition, what are the typical dispute resolution mechanisms utilized?
Thank you very much, Nikhil. I should also say, because Ms. Diamana Diawara will kill me if I don't, I'm also an ICC YAF representative, so I have to throw that in there because it is an honor to be here generally speaking on the panel, but also with my little YAF Africa chapter cap on. So thank you so much for the introduction, Nikhil. Jumping straight to the question, relatively simply speaking, the standard form contracts that we're seeing a lot in particular in sub-Saharan Africa are, well, I mean, I think we can say across the board in Africa, holistically, is really those of FIDIC. You mentioned FIDIC before. We're seeing a lot of FIDIC silver, yellow, and red books being utilized. The NEC, less so of the NEC 4. There's been a little bit of a slower uptake on NEC 4. Certainly in South Africa, we're seeing a little bit of that uptake, but predominantly FIDIC 99 edition and 2017 edition. And then really looking towards sub-Saharan Africa specifically, the JBCC standard form contract, as well as the GCC standard form contracts. And COLTO is another set of standard form standards and specifications that are utilized as well. Those are really for road and bridge projects. So those are really across the board, the standard form contracts. Of course, within the renewable space as well, looking more at infrastructure and energy contracts. A lot of bespoke type contracts are being utilized as well, but those are predominantly premised on FIDIC Silverbook, to be honest. That's what we're seeing a hell of a lot of. Turning then really to the dispute resolution mechanisms that are utilized, within all of these types of contracts, we're seeing a lot of the time is really a tiered type of dispute resolution process. So it usually starts off with some kind of engineer's determination, moving then to or project manager determination or decision in relation to a particular claim or a dispute. You can have sorts of expert determinations that are utilized, and then it moves through a range of different tiers, from amicable settlement processes to adjudications, and then going all the way towards arbitrations as well. Obviously, within the context of FIDIC, the process generally is an engineer's determination. If you don't like that determination, you then move to an adjudication type process. Adjudication is also common in an NEC contract. And then from adjudication, if you don't like the outcome of that, you then have the option to go to arbitration. And FIDIC standard form is obviously guided by the ICC rules. So that's the general kind of tiered resolution process. But I think what we're wanting to focus on here is not necessarily focusing on dispute resolution, but also dispute avoidance. So looking at those types of processes, you've got within those mechanisms, you've got the types of resolution that includes mediations, and then obviously your amicable settlement and your adjudications and arbitrations.
Great. So within those mechanisms, what can be viewed or utilized as assisting avoidance disputes as opposed to ADR?
Thank you. This is a really good question. It's a really important question, and if I may touch on our previous speaker Peter's emphasis in driving and understanding dispute resolution mechanisms, but more importantly, from our perspective, I think it's important to understand that you've got these mechanisms in place, but you also need to focus on avoiding disputes generally as well. And I think from this perspective, it's something that I'm quite passionate about, in particular because I'm a contentious lawyer. But I think that there's this predisposed view on trying to just resolve disputes. But I think we should all be taking a step back and trying to avoid disputes as well. And that's there really is an art to avoiding disputes. And then if you can't avoid disputes, obviously trying to resolve them as well. And for these purposes, I think I'm just really going to focus on FIDIC here because it really gives the most recent and relevant and express drive toward dispute avoidance. It's important to remember here that there really is a difference. There's a difference between avoidance and there's a contradistinction between that and resolution. There are always a number of ways in which you can resolve your dispute, but that's very different, obviously, to avoiding disputes. Fundamentally, for project security, for continuity of works and relationships between the various parties in the real estate, infrastructure, and construction kind of space, avoiding disputes really should be front of mind. And I don't think it gets enough airtime, certainly not as much as it should. And looking at FIDIC in particular, in its 2017 edition, it really does go quite a long way in trying to achieve dispute avoidance. And a couple of points here, I'm gonna list or run through five or six points very briefly, knowing we're under quite a bit of time pressure. But the first point is really claims versus disputes. FIDIC has done a really good job in distinguishing between what a dispute is and what a claim is. A claim really is an exercising of an entitlement under a contract in a real estate, infrastructure, or construction-related dispute. And having a claim doesn't necessarily mean you're really preparing for war. You're exercising an entitlement under a contract that you believe exists, whereas a dispute is in the event that that entitlement is disagreed with between the parties. And FIDIC has defined the two very, very clearly. Another way of achieving dispute avoidance is this implementation of this adjudication board. So under FIDIC, many of you will know that previously under the 99 edition, you had a dispute adjudication board. Now you have a dispute adjudication and avoidance board, and avoidance is this real big focus, and its specific powers are given to what we call the DAAB now. A standing DAB is another big process. Under the 2017 edition, there's no longer this process of having an ad hoc DAB that's just simply appointed, or DAAB rather, that's simply appointed as and when a dispute arises. Your DAAB is intended to specifically be appointed right at the beginning of your project. And that gives a range of benefits to the parties. The DAAB is on site regularly, is able to understand the workings and progress of the board and of the project as works progress. Looking to dispute avoidance in particular, subclause 21.3 of the FIDIC 2017 editions, and that's red, yellow, and silver. So you're looking at your EPC, your construction, and your design as well. And 21.3 specifically deals with avoidance.
Hi, boyfriend. Boa, how are you? How was your week?
Sorry about that.
Is it 1 week or 2 weeks?
Admin, could we
It's like 2 weeks, yeah?
mute one of the
Since the other
attendees,
Friday.
please?
How are you doing? Me, I'm good.
I think we needed that interjection to echo enough just before lunch. Sorry, Chloe. Chloe, just trying to get you back. We can't hear you. Sorry.
No problem.
Okay, there you go. We can hear you now.
Am I back?
Yes.
A nice little interjection there. I'm assuming that's just a prompt for me to hurry things along. We don't want to avoid any disputes here. So 21.3 under FIDIC specifically deals with informal assistance that the DAAB can deal with. It can be initiated at any particular period in time during the project, except when the engineer, we know the engineer has a fundamental role, a role in FIDIC. So it can be initiated at any particular point in time, except when the engineer is undergoing its process of making a particular determination. It is initiated by the parties jointly by agreement, and as to the binding nature of it, it is not binding, which gives I suppose it's a good and a bad thing that it's not binding, because it gives the parties some certainty that they can have these kind of discussions without being forced into a process, without any outcomes being binding. But likewise, it also gives the parties comfort that the DAB or the DAAB can initiate this process. So 21.3 is really quite important because it gives the DAAB and the parties some real meat to trying to avoid disputes during the course of a project. It doesn't mean that you have to then initiate a dispute and go to a DAAB right at the end of the outcome of any of this. Of course, those rights remain, and you're always entitled to exercise those rights to go to a DAAB. But having this particular meaty provision that allows the parties to engage in this kind of process is really quite something, and it's really is the first of its kind that we've seen in standard forms. Another really nice tool from an avoidance perspective is also just trying to make sure that the DAAB is regularly visiting site. It's another way which allows the parties to engage with the DAAB in trying to avoid disputes before they arise. And then the last point really on actual avoidance of disputes within the FIDIC context is the engineer's role as a mediator. And you'll recall under the 99 edition, the engineer is really required to determine claims that have been brought by the contractor. And what FIDIC has done now is the engineer has this role of looking at disputes, or sorry, rather claims by the employer and by the contractor. But he's also obligated to engage in in sort of consultation processes through the process of giving his determination, which is another really handy tool in trying to avoid disputes generally. And then the final point on this really is just looking generally at contract management through all of these standard form contracts. Obviously, with a focus on FIDIC, just because it's a really, really nice update to the processes generally and looking at avoidance. But generally, there's a big focus on contract management. Things like early warning provisions, management of claims, progress meetings between the parties, and looking at risk registers, for example, under NEC. Those types of mechanisms are really quite important in trying to bring together the ability of the parties to avoid disputes before they arise. Your dispute resolution mechanisms, they exist, they're there, and they're not going to go away. But it is certainly more efficient from a relationship perspective, from a cost perspective, as well, to try and avoid disputes before they arise. So having those kinds of mechanisms in place is what we're seeing being utilized in trying to get to a point where they can be avoided.
Thanks, Chloe. Indeed, dispute avoidance in construction infrastructure projects are very important, mainly because these disputes arise very early on during the pendency of the contract. And these contracts are for 10, 15 years or less, or more, sorry. So dispute avoidance becomes very important. Thank you, and we'll come back to you further on that if we have some time at the end. As Chloe mentioned, with regard to dispute resolution in construction, real estate, and infrastructure, there are a number of players. It's not simply a lawyer. You would have a quantity surveyor, you would have engineers, contract managers. So just to get an opinion from Martin, who is a project consultant, but also an ADR specialist. Martin, what role do project consultants play in dispute avoidance in construction, real estate, and infrastructure projects?
Thank you, Nikhil, and thank you to ICC Kenya for inviting me. I think I'll build on what Chloe has said, that disputes in construction project normally can be avoided, and dispute avoidance is one of the primary roles consultants in a project play. Construction disputes have a unique nature because there is a third party who is the consultant. The consultant in a FIDIC contract is the engineer. In the JBCC contract is the architect. And this is a third party to the contract, but they have specific roles and which influence the outcomes of the project. So it is these people who have to ensure that the project runs smoothly. So what role do they play to ensure that they can avoid disputes before they get out of hand? I think, in my opinion, there are few things they can do. And the first item I would like to discuss is the composition of the consultancy team. A project has various specialities. So let's assume it's a real estate project. You have an architect, you have an engineer, you have an electrical and mechanical engineer, you have a quantity surveyor. All these people need to be on board before the project commences to ensure that the roles are properly defined. Because if roles are defined further down in the course of the project, you are likely to have disputes arising. So it's good to have the composition of the consultancy team well identified when the project starts. Going to the next point will be understanding the forms of contract between the parties. The parties to the contract, which is the employer and the contractor, they need to understand their roles. They need to understand the duties they have to play in the contract. They need to understand specifically the clauses in regards to dispute resolution. Because as Chloe said, there are items of claims and there are items of disputes. A claim, as Chloe said, is not necessarily a dispute because it's something that emanates from the duty of what the contractor is implementing. So the consultancy team needs to identify what are rightful claims and what are potential disputes. And by explaining this to both parties, the consultancy team is able to at a very early stage, avoid escalation of claims into disputes. The third point I would go to would be project documentation. We realize that majority of the disputes that arise come up because of lack of documentation in a project. You'll find instructions were given to make changes, specifications were changed by verbal instructions, and this down the line cause disputes because one party will say they were told to do X, change X to Y, but then the party which gave the instruction refuses to admit that they made these changes. So as a project consultant, it's always important to ensure that documentation is done properly and assented to by both parties to ensure that any changes to the scope that was agreed as the contract was beginning and any amendments is signed on by both parties, and this avoids any claims or disputes that may arise from such instructions. On my last suggestion as to what role consultants can play in avoidance of disputes is ensure that project details are prepared well in advance. You'll find that there, as I said earlier, there are various aspects to a construction project, and the various specialities need to prepare documents, prepare bills of quantities, and prepare specifications well in advance before the project contract is signed to ensure that everyone, as they get into the project, both parties, the developer and the contractor, they are well aware of their roles and responsibilities. We have noticed a situation where a design has not been frozen by the time a contract is signed, and down the road when specifications are given, contractors make claims which are then denied by the employer, and this gives rise to disputes. So if such designs and instructions and documentation can be done well in advance, it would play a huge role in ensuring that disputes are avoided in construction projects. I think that's all for now.
Thanks for that, Martin. And in your experience, what disputes are emerging in the industry?
We are living in a world where employers and project developers are looking to save cost as much as possible. I will mostly in this aspect deal with real estate projects. We've seen, especially in the East African market, a proliferation of real estate developments. But the conventional method of doing things is being overlooked. Previously, a developer would look for a contractor, have them procure everything in the project, and and then pay for the services. But we've come to a point where developers trying to save cost will give labor contracts to contractors. So essentially, you are allocating part of the responsibility to the contractor while withholding part of the responsibility. And from a mathematical point, we are looking at labor being a component that is about 30 to 40% of the project. So the developer is left with 60 to 70% of the risk. So in a case where, let's assume you had given an instruction for a contractor to do class 25 concrete, and you have provided the materials and the contractor was supposed to do labor only. If after that has been done, a case comes where the concrete does not meet the test and the results fail, a dispute arises as to who is assigned blame. If the contractor was due 30% based on the labor element, and in this case, the material element is 65%, and that has also been lost due to the failure of the labor contractor. How do you go about making such a claim? The claim might even go beyond the full contract sum given to a contractor. So as a consultant and as a dispute resolver, it would be prudent to ensure that duties, risks, and responsibilities are assigned way in advance where such scenarios might occur. And labor contracting being a thing that is being widely accepted going forward, it would be very crucial as we draft contracts and dispute resolution clauses for such contracts that we are very careful as to who we ascertain such blame to.
Thank you, Martin. Very important point. It's key to include as much as you can in the contract, and during the course of the contract, amending the agreement or reaching separate agreements for each issue is very important for dispute avoidance. Paul, moving on to you. Chloe had mentioned earlier on that one of the ways of ADR in construction, infrastructure, and real estate is adjudication. She talked about a dispute, a DAAB. So Paul, in Kenya, there's no statute, as far as I'm aware, governing construction adjudication. Is the absence of such a statute on construction adjudication affecting the enforcement of adjudicators' decisions in Kenya?
Thank you very much. It's true, we do not have an adjudication statute in Kenya. It's in the works and it has been there for a long time. CIAB prepared a draft or a bill close to 10 years ago, sent it to the AG's office, which was very receptive, but CIAB recalled that bill for corrections and further consultations. Meanwhile, there was the ADR policy, which was launched, and obviously policy was given precedence over a specific statute. So we don't have an adjudication act as such, but it's coming, we hope, and very soon. Now, as to whether the lack of a statute is a good thing or a bad thing, that is open to debate. I say that because if you look at the inconsistency in the way the courts have interpreted, for example, Section 6 of the Arbitration Act or Section 35(3) of the Arbitration Act and other sections of the Act, perhaps we are better off without a statute. Right now, there are very few cases in the courts involving adjudication and involving DBs. And the reason is simple. There is no statute. So the parties are tied to the contract and they comply with the contract. If the contract is breached, the remedies are in the contract. So that is why I'm saying perhaps it's a good thing that we do not have an arbitration, we do not have an adjudication statute. Now, the last point on that issue is that courts, when faced with matters arising from DBs and from adjudication, simply apply the law of contract. I'll give you a case. It's called Midrock versus Cabinet Secretary, Ministry of Environment. And I'll quote very quickly some two short paragraphs in the decision which was given by the judge. The judge in that case was Jackie Kamau, who is a chartered arbitrator and was a very active arbitrator, in fact, chair of CIAB Kenya branch before she went to the bench. She says, the issue between the parties, I'm reading paragraph 29, the issue between the parties is not a legal issue that should be decided by this court, but rather by the engineer in the first instance, as parties are bound by the terms of the contract. That is paragraph 29. I'll skip and read something brief from paragraph 35. The court considered the resolution of the dispute through the mechanisms provided in the FIDIC conditions of contract as most suitable in the circumstances of this case. Paragraph 37, for the avoidance of doubt, the court hereby direct the proceedings herein be terminated and that parties commence settlement of their dispute in accordance with FIDIC conditions of contract. I'll stop there. Thank you.
Okay. So are there any challenges that you'd want to discuss regarding the establishment of dispute boards? Now that we've talked about, some of the issues that may arise or may not arise because there's no statute governing DABs.
There indeed are very many challenges. I will list just a few. One is that some organizations, parties, that is employers and contractors, see DBs as a needless expense. So they avoid avoid appointing a DB. Simply, it's the same way you avoid going to a dentist until you have been awake the whole night because of that toothache. Organizations are not different. They try to save money. They try to avoid the pain of a DB, so they avoid appointing a DB to the last minute. Actually, the FIDIC contract says that, the 2017 Red Book recommends that a DAAB should be appointed within 28 days of the letter of appointment. Actually, it recommends that the DAAB should be appointed even before, but the last time is within 28 days of the letter of appointment. So we have situations where contracts are going on, projects are going on without the benefit of DAABs or DABs, as the case might be. Now, the other challenge is even when the DAB or DAAB members have actually signed the contracts, at the FIDIC contract, there is requirement for a notification of commencement of the DAAB or DAB. Sometimes the parties, the DAB members sign the contracts, both parties sign, but the parties sit on the contracts. They don't give that notice. So again, the benefit of the arrangement is lost. Of course, that is done to save money, but researchers have shown over and over again that saving money on DBs is a forced saving because the total cost, the total fee paid to DBs is minimal compared to the cost of the project. That aside, the disruptive nature of disputes has got very serious implications in construction and infrastructure projects. Because of interest payment, a lot of projects are financed by credit, but also because of knock-on effects. There are some things, there are some activities which cannot start until others are completed, so there are knock-on effects. I'll mention just one more, and it's that sometimes even when a DB is in place, you find parties very reluctant to give the DB the necessary information, so that in some cases you have a DB in place, it is making site visits frequently as required, it is being paid its fees, but it's being kept in the dark deliberately by the parties. You ask for information, you ask for site minutes meetings, you ask for details of variation orders, you get nothing. Thank you.
Thanks, Paul. Very important points, and I think we were also involved in a Silver Book contract where we saw that at the point of appointment of the DAB, the party who didn't want to actually go into dispute resolution used every mechanism to delay the appointment of the DAB. That's by appointing a member, appointing a chairman. Once the appointment authority actually did that, signing the actual agreement, you can delay the whole process of the DAB and therefore dispute resolution, especially in Silver Book contracts, because of that lack of clarity. Just moving on to Howard now, just dealing with infrastructure disputes. Obviously, infrastructure projects are different. because mainly due to their size and the term that they're going on for. What are the unique challenges or qualities of a dispute in infrastructure projects?
Thank you so much, Nikhil, and thank you, ICC, for affording me this chance to speak. I'm coming in when everybody has said everything, and I think when Chloe started, she did a great job highlighting important issues, especially about feeding contracts. I'll just try to add to what my fellow great panelists have already spoken, but try to paint a picture of the uniqueness of infrastructure contracts. Unlike scenarios where you have contracts like construction of buildings, where you are doing a building in a certain location, this is 3 acres and you are putting up a building here. Infrastructure projects, their characteristics is that first, you will find most of them are large size. The sheer size of it and the complexities of the projects makes them unique and introduces something different about the disputes that are likely to arise. For instance, when you are crafting infrastructure contracts, because perhaps you have a project that is spanning 500 kilometers, the amount of unpredictabilities increases. It might not be possible. For instance, it might be easy to tell what type of soils you are going to put up a building on 3 acres, because 3 acres is a small place. You can easily visualize everything and most of the details that you'll want to know before you form the contract. However, if you're doing a project that is running over 500 kilometers, even the degree of details that you obtain when you are carrying out site investigations is minimal. And if you must collect full details of that length of the road, of the space that you're going to be constructing, it might become prohibitively costly to do it. And so whenever we are dealing with infrastructure contracts, we must from the word go realize that we are faced by a lot of unpredictabilities. We are faced I could say, whereas we all want to work toward avoiding disputes, but when we come to the space of infrastructure, it might be reasonable for us to say we have to accept to live with a dispute because they're likely going to come, since it is next to impossible to be able to foresee everything that is going to happen. Secondly, even if you try to make as much details as possible of your contract, give a lot of details, develop the terms clearly, remove ambiguity from the contracts as much as possible, you might find that most infrastructure projects, probably the clients happen to be governments. And a contract might not be able to cure everything and every likelihood scenario that might happen with a government, because governments are run through politics, and politics keep on changing every other time depending on who are the players, who are the opponents, and what are the new things that are coming in, what are the new legislations. And because all these things will keep on happening along the project implementation time, we might not fully avoid disputes, and that's why we must embrace ADR, just so that it saves us from going all the way to the courts. And it can save us time, it can save us effort and money. But I also wanted to highlight something else, most importantly, that when we begin dealing with projects that are highly complex, that is the point when we want to leverage on practitioners with knowledge in the subject matter. Okay? And that's where ADR and arbitration comes in very strongly. Whether you're looking at the construction contracts, where you're dealing with contractors and clients, or whether you're dealing with consultants contracts, where you have professionals engaged to assist the clients to fulfill or to implement the projects. This is the point where we need to take advantage of professionals who will get training in the area of arbitration, but since they have in-depth knowledge of the subject matter, they can then help us to navigate either to reduce the impact of the disputes, to avoid some disputes which can be avoided. Because if you have like the consultants, what Martin was talking about, if you have consultants who are good at their work, they might help you a lot of the times to avoid those disputes.
Thank you. And just final question, I think. What are the recent trends you've seen for dispute resolution in large infrastructure projects, not only in Kenya, but maybe regionally in East Africa?
Probably I would pick it from the last point that I had made, where we are trying to get more people trained with knowledge in the subject matter. And I saw recently the Chartered Institute of Arbitrators has made very deliberate decisions to begin going out to reach out to the other professional bodies that carry professionals in other areas, like the Architectural Association of Kenya, the Institution of Engineers of Kenya. I know that relationship had been there before, but I've seen more activity, more engagement, and I've had a word like with the chairman before, where he was encouraging me, why can't we get more engineers, more quantity surveyors, and more architects being interested? Because earlier on, Professor Githu Muigai made an observation, and which is an observation that all of us agree with, and also I think Honorable Justice Angawa alluded to the same, that whereas we do appreciate the role of advocates in resolving disputes, sometimes they bring too much court into arbitrations. And bringing too much court into arbitrations, it doesn't come with a good intention to help solve arbitration issues. It comes to frustrate arbitration and drag the process back, probably drag them over a long period of time and create more confusion than creating clarity. But as we move forward, we are finding, since we can all see this, it's good that those statements came from polished advocates, people have practiced. Some of them have practiced both from the bar and from the bench. It gives us hope, because if it was coming from an engineer, it would have looked like fitina, like someone is trying to keep another one out of the business. So as we move forward, you realize some of the trends happening in infrastructure. In infrastructure, we have seen continued changeover of forms of contracts. When I was much earlier in my years of practice, infrastructure contracts were mostly modeled alongside FIDIC Red Book, unit rates contract. Because the advantage of unit rates contract is because you just develop unit rates and you wait for the day when things can change. I told you at the start that there are many unpredictables on an infrastructure contract. So we've worked on unit rates contract for a long time, but as we move toward this age, the last couple of years, we've now started embracing lump sum contracts. We've started embracing the FIDIC Silver Book on infrastructure projects. It used to be maybe on only mechanical works and things that are made in the factory and then just installed on the ground. But now you can get a Silver Book contract for a dam or for a road project. And it has also progressed, I think, in the country. We now have a few examples. Based on the type of financing for projects, we're now moving from the lump sum contracts, and we are also seeing PPP forms of contracts, which come with their own unique challenges that were different from what we could experience in a unit rates contract and even in lump sum contracts. Sometimes you've seen people making huge mistakes because they are trying to solve problems of a lump sum contract using the unit rates contract, using the knowledge of the unit rates contract, and therefore creating a dispute where they wouldn't have been won. A good example, there's a controversial case, a very controversial case on Kenyan soil about the Aurora and Kimwere Dam, where everybody believes that there was a scandal. But if you sat back and analyze the situation from a strict contracts perspective, you realize there is no scandal in the contract. There is a scandal in the investigation, where there is an attempt to solve issues of a lump sum contract applying unit rates contract, where someone wakes up and says that, this contract was 25 billion, now it's going to go on at 15 billion shillings. But this means that if it's a lump sum contract, what it means is that you've cancelled one contract and you're signing another contract without having to go to do any procurement procedure and that kind of stuff. So as these trends change, we have also to keep on changing our minds and our understanding of these contracts so that we avoid escalating things that could have been resolved contractually. We push them into disputes that could be very costly. Thank you.
Thank you, Howard. I think, Madam MC, do we have time for a question? Before? No? Okay, no, straight up. I think before, thank you to my panelists. And as we leave, I've been informed I cannot take any questions, but okay.
Thank you for the indulgence. My name is Jacqueline Waihenya. I'm the Vice Chair of the Chartered Institute of Arbitrators. I just wanted to clarify just very briefly, and I'm doing it in probably 1 or 2 sentences. In November of this year, we'll be having a training on FIDIC construction contracts. We're doing it with Africa Construction Law as Chartered Institute of Arbitrators. That is one issue, I think, which can address the many issues and the challenges that are coming with, we call it copy-paste of different suites, and ultimately coming up with a contract that doesn't ultimately solve the problem it is supposed to address or achieve the goal and the project that it is supposed to create. That is number one. Number two, on the framework, the legal framework, I sat on the National Steering Committee on the ADR policy, which was, we worked with the national NCIA. And one of the proposals that we have made, because I was the convener of the legislative policy proposals, we sat with Dr. Mwigwa in that committee, and we have proposed a national construction adjudication bill. And I know NCIA is also working on having a stakeholder engagement on the same. It creates a legal framework, and it also accommodates the standard form contracts. So maybe we can just look out and participate in the discussions in those particular areas. Thank you. Thank you for your indulgence.
Thank you very much for those very useful updates. So thank you again to the panelists. And I think as we leave, I'd just like to call Laura Lusici to give a short presentation on how young practitioners can enter into the construction ADR field. I think the rest of the panelists we can leave. Thank you.
Thank you, everyone.
Good afternoon. Of course, I acknowledge that we are running out of time, and perhaps I'm the person standing between you and your lunch, so I'm going to try and be very brief. Thank you, Nikhil. My name is Laura Lucigi. I'm a senior associate at J. Miles & Co. And I will just very briefly speak about the trends in construction disputes and how young practitioners or less seasoned practitioners can plug into the arena. So I'll break my, my talk into two. I'll first talk about the trends, and then later on I'll talk about what we can do to get into that. Now, construction disputes have been on the rise, particularly following the impact of COVID-19 and the war in Ukraine. We are currently advising on a matter actually where there's a dispute that has arisen, and it's based on the regulations that Kenya had to put in place to curb the pandemic, where now you have social distancing, the requirement of sanitizing, the curfew hours. They had impacts on a construction project. A construction project because, of course, there are additional costs involved, and because of the curfew hours, it also meant that the time for the project had to be increased. So we are seeing a rise in construction disputes, and given this rise, it's important to use the right processes to resolve construction disputes as swiftly and as cost-effectively as we can. I think that has been discussed by the immediate former panel. Because most construction projects are actually time sensitive. So, no parties in construction projects want to be, involved in long disputes that perhaps we see in our courts. A survey was conducted recently, and it showed that parties in construction, the first mode of dispute resolution that they prefer is negotiation, followed by adjudication and then mediation. You see that they try to steer off from arbitration and litigation, which are, they are adversarial in nature. Of course, they take a lot of time, and given the fact that they take a lot of time, they are obviously expensive. So having looked at the trends very briefly, what steps can we take as young practitioners to get into this arena? Now, the first step I would recommend, of course, is mentorship, and I think Kamau Karuri, Senior Counsel, talked about that in the first panel. We cannot underscore the critical role that mentorship plays in the growth of the profession of a young practitioner, and much so in crafting a practice in construction. So that's very important, and that's something to bear in mind. Of course, in this room, there are great men and women who we can use, we can approach to be our mentors. The second point is registration for trainings. Locally, the Chartered Institute of Arbitrators offers a myriad of trainings in alternative dispute resolution mechanisms, of course, including adjudication. I think, if I'm not wrong, adjudication is actually a one-day training, and that is something that a young practitioner can plug into. Also, looking at the international space, the King's College in London offers a one-week program on training on FIDIC contracts. And the world now has become a global village. As has been mentioned earlier, there are a lot of cross-border transactions, and so it's important to ensure that we are on top of these standard form contracts that are utilized by parties in constructions. The third point is keeping up with trends relating to construction, and keeping up with these trends means, reading articles, appraising yourself of the different FIDIC standard contracts, the yellow book, the red book, the silver book, keeping yourself appraised of the revisions in these books, the standard form contracts in the new engineering contract, because these are the forms of contracts that are used by parties more often. Also, a young practitioner may consider participating in the formulation of articles and contributing to articles on topical issues surrounding construction, and this assists in putting your name out there. And in conclusion, I wish to introduce you to and invite you to participate in the Africa Construction Law blog. I serve as the general editor for that particular blog, and the aim for the blog is to actually keep the African continent up to date with construction developments. And so we have, and this has been made possible by the willingness of various contributors across the continent to write and inform the continent about these developments. And so please feel free, if at all you wish to contribute, to reach out, and we can consider the article and put it up for, the growth and prosperity of construction across the continent. With those remarks, ladies and gentlemen, I wish to stop there because I know we are running short of time, and I want to thank the ICC for the opportunity to give this short presentation. Thank you.
So guess what? It's lunchtime. So thank you very much. So I think we break for lunch now. It is 1:55. We take a 40-minute lunch break. So back at 2:35. Okay, so, oh, good question. Lloyd? Okay, so lunch will be served at the restaurant on the second floor. So out that way into the main reception and then on the second floor. So enjoy your lunch, everybody, and see you at 2:35. Hopefully this time we won't have technical issues. So 2:35 start. 2:35.